Oh, resend them the link. Technology, gotta have it. There you go. Right, we're gonna go ahead and start the meeting. At this time, we will do roll call. Chair Wallen here, Vice Chair Dufferin,
Here.
Commissioner Greenwald here, Commissioner Towler,
Here.
Commissioner Yen,
Here.
Commissioner Lowry,
Here.
Commissioner Sheets. Please mark him absent. Commissioner Osterson. Please mark him present once he joins us, right? And with staff, we have Executive Director Armstrong,
Here.
Associate Counsel Bassett here, Senior Legal Researcher Hayden here, Executive Assistant Pedroza here. And then we also have our let's see, is our investigator here? Investigator Terry. Oh, here he comes. Oh, right on time. And then we also have our Deputy Attorney General, Nina St. Jules here. Please stand for the pledge. And pledge allegiance to the flag
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This time we will open it up for public comment. Executive Director Armstrong, have we received any public comment by email?
I've checked the commission's main email just now, and there has been no public comment submitted by email.
Are there any members of the public who are attending in person or virtually who wish to make public comment?
I do not see anyone here in the room in Reno in person, and I will defer to Executive Assistant Pedroza if anyone on the Zoom would like to make public comments.
We do have members of the public on Zoom and none of them have indicated they would like to make public comment at this time.
Okay, next item, item 3, approval of the February 15th, 2023 commission minutes. Commissioner Sheets and Yen were not present, therefore they may not participate in this item. All other commissioners may participate. Are there any additions or corrections to the minutes as read? Okay, if not, I'll entertain a motion to approve.
So moved.
Is there a second? A second. All those in favor say aye. Aye.
Aye.
Motion carries. Next item, item 4. Hearing on deposited motions in consolidated case numbers 20-081C and 20-085C regarding Leonardo Blundo, member Board of County Commissioners, Nye County, State of Nevada, including providing authority to the chair of the commission to prepare and issue the order reflecting the commission's decision on other matters relating thereto, in consultation with counsel for the commission. I would like to open the item and state that proper notice has been provided and waivers have been received for consolidated ethics case number 20-081C and 20-085C Blundo. The members of the review panel, Vice Chair Dufferin, Commissioner Grunwald, and Commissioner Sheets may not participate in the consideration of these deposited motions pursuant to NRS 281A.2204. All other commissioners may participate and vote on this matter. This time, I would like to ask the counsel for the parties to identify themselves and their clients for the record.
Good morning, Elizabeth Bassett, Associate Counsel for representing the Executive Director.
And Brian Hardy with the law firm of Marquis Arbach on behalf of the subject. I have with me as well via video Tricia De Los Santos, who's one of my associates who's working on this as well.
Welcome. All right, we have 2 deposited motions for the commission's consideration. For presentation purposes, Ms. Bassett will first present an argument on the executive director's motion for summary judgment. Second, Mr. Hardy will present argument on Mr. Blondo's opposition to the executive director's motion for summary judgment, as well as on Mr. Blondo's motion for summary judgment. Third, Ms. Bassett will present argument on the executive director's reply in support of his motion and on the executive director's opposition to Mr. Blondo's motion for summary judgment. Fourth, Mr. Hardy will present argument on Mr. Blondo's reply in support of his motion for summary judgment. At this time, I would like to ask Ms. Bassett to present any argument on the executive director's motion for summary judgment.
Thank you. Good morning, commissioners. For the record, I'm Elizabeth Bassett, Associate Counsel for the Commission on Ethics, representing the Executive Director in this matter. This matter concerns subject Leonardo Blendo, a former Nye County Commissioner. In addition to his former public position, Mr. Blendo also owned and operated a restaurant in Nye County. During the COVID-19 pandemic, Nye County received COVID relief funds for use within the county. The commission, including Mr. Blendo, were responsible for setting policies for those programs used to distribute the county's COVID relief funds among local businesses. As the sole owner of his business, Mr. Blendo submitted multiple applications to the county on behalf of his business requesting COVID relief funds. His business ultimately received funds under several of the county's programs, including $50,000 under the CARES Act Small Business Working Capital Program. 2 consolidated ethics complaints were filed alleging that Mr. Blendo violated the ethics law by using his public position to improperly benefit the interests of his business, to which he owes a commitment in a private capacity. Following an investigation, it's the position of the executive director that Mr. Blendo attempted to benefit his business by demanding special treatment and attention to his applications for COVID relief funds from his subordinates, that he used government time, property, and equipment to benefit his business's significant personal and pecuniary interests, and that he not only failed to provide a proper disclosure before voting in favor of an agenda item that financially benefited his business, but that he in fact provided a misleading disclosure that prevented the public from determining his interest in the agenda item. As a county commissioner, Mr. Blendo was not precluded from applying for COVID funds for his business or from interacting with county staff regarding the processing of his applications. However, the ethics law requires that as a public officer, Mr. Blendo is required to make proper disclosures to inform the public of his conflicts of interest and to ensure that he does not use his public position to seek special treatment for his business. The issue in this matter, however, is that Mr. Blendo failed to comply with the ethics law at every step while applying for COVID funds for his business. Accordingly, we respectfully request the commission grant the executive director's motion for summary judgment regarding Mr. Blendo's violations of the ethics law. One of the violations at issue is Mr. Blendo's failure to properly disclose his conflict of interest regarding an agenda item that came before the county commission in violation of NRS 281-420 subsection 1. The Nye County Commission was responsible for adopting policies governing how local businesses could apply for and receive COVID relief funds. After the initial adoption of these policies, Mr. Blendo submitted applications on behalf of his business to receive relief funds. Knowing that he had submitted these applications on behalf of his business, Mr. Blendo attended the November 10th, 2020 commission meeting, at which one of the agenda items was the amendment of one of the policies regarding one of the programs that he applied for funds through. When that agenda item came up for discussion, Mr. Blendo disclosed only that he held a liquor license and that he was utilizing the programs the commission was setting policy for. However, Mr. Blendo also then misrepresented that he did not have a direct pecuniary interest in the policy. Mr. Blendo voted in favor of the amendment to the Nye County's CARE Act policy, which had the direct effect of increasing the amount of funds that his business received by $35,000. This commission has determined that the ethics law requires a public officer to disclose sufficient information to inform the public how their private matters and associated interests would reasonably affect their decisions on matters before the public board on which they sit. The purpose of this required disclosure is to promote accountability and scrutiny of the conduct of government officials and to dispel any questions about the public officials' conflicts of interest. The issue in this matter is not that Mr. Blendo was unable to participate in the vote on the agenda item at issue. Had he made a full and proper disclosure regarding his conflict of interest that complied with the ethics law, he could have properly participated in and voted on the agenda item at issue. But the undisputed facts show that Mr. Blendo's disclosure was instead insufficient and misleading, and therefore a violation of NRS 281-420 subsection 1. Mr. Blendo failed to provide the public with sufficient information to inform them how his private interests would be affected by his vote to increase the CARES funding limits. To be sufficient, Mr. Blendo was required to disclose to the public that he applied for funding on behalf of his business under the same program at issue, and that a change in the policy of the program, and especially an increase in the funding limits, would have a direct pecuniary impact on his business and therefore himself. Further, as the sole owner of his business, the pecuniary interests of that business are imputed to Mr. Blendo under the ethics law. Mr. Blendo's statement that he did not have a direct pecuniary interest in the CARES policy was therefore incorrect. The effect of this statement was to portray to the public that Mr. Blendo did not stand to financially benefit from the county's care policy or any change in that policy. The disclosure therefore failed to meet the requirements that it reasonably inform the public regarding the effect of his vote in favor of the amendment on it and what that effect would be on his personal private matters and associated interests. We therefore respectfully request that the summary judgment be granted in favor of the executive director as to Mr. Blundo's violation of this code section. Additionally, because he did not make a proper disclosure under 420 subsection 1, Mr. Blundo was not entitled to take advantage of 420 subsection 3's presumption that he was not required to abstain from participating in or voting on the agenda item. Summary judgment should therefore also be granted in favor of the executive director on this code section. Summary judgment is also appropriate as to the executive director's allegation that Mr. Blundo violated NRS 281A 400 subsection 9 by attempting to benefit his pecuniary interests through the influence of his subordinates. The evidence in this matter shows that Mr. Blundo repeatedly entered the Nye County Finance Office through a staff-only entrance, remained in staff-only areas that are not accessible to the general public, and he demanded assistance from county staff without scheduling an appointment as was required for members of the public. The evidence further shows that Mr. Blundo behaved in a way that caused county staff to believe they were required to provide him with special treatment in processing his CARES applications, or else their jobs may be at risk. Mr. Blundo's behavior was so disruptive and upsetting to county employees that several quit as a result, and the county's comptroller had to lock the staff door entrance and provide Mr. Blundo notice that he was no longer welcome in staff areas and must only interact with her regarding his CARES applications. Mr. Blundo also made numerous phone calls to Nye County staff to discuss his CARES applications, including a 40-minute phone call regarding an application for rental assistance that had been denied, and that had been denied by the comptroller. During that call, Mr. Blundo used his public position to pressure the comptroller to change her determination denying his application. The comptroller testified that Mr. Blundo's behavior during that phone call caused her to believe that her job could be at risk if she did not reconsider the denial of the application. Again, Mr. Blundo was not prevented by his public position from seeking assistance from county employees on his applications. He was required, however, to comply with the requirements of the ethics law by ensuring he did not use his public position to benefit his personal interests. The evidence shows that instead, Mr. Blundo used his public position to pressure his subordinates to provide him with special treatment. Summary judgment should therefore also be granted as to this code section. These same facts also support summary judgment in favor of the executive director as to Mr. Blundo's violation of NRS 281A 400 subsection 7, using government time, property, and equipment to benefit his and his business's significant personal and pecuniary interests. The undisputed facts show that Mr. Blundo improperly accessed private, non-public areas of county offices and repeatedly insisted on receiving county staff time not available to members of the public to benefit his own significant pecuniary interest. Summary judgment is therefore also warranted in the favor of the executive director as to this violation. As requested in our motion, the executive director is respectfully requesting that the commission grant his motion and find 12 violations of the ethics law against Mr. Blundo. Thank you for your time. I'm available to answer any questions.
Thank you very much. Mr. Hardy, will you please present any argument on Mr. Blundo's reply in support of his motion for summary judgment?
And the opposition
In the
and
opposition, yeah.
opposition in our pending motion.
Yes.
Absolutely,
Sorry.
Madam Chair, happy to do so. First of all, I want to thank the executive director and associate counsel. As you can tell from the binders of documents that you guys have all received, there was a lot of discovery in this case that was done, and it was done very professionally. One of the things that we have all done is a lot of briefing in this case in order to make sure that the facts in this case are able to be relayed on to you as the commissioners in a way that makes the most sense. And I think it makes the most sense to take this in kind of a chronological factual section, because I want to make sure and address some of the facts that associate counsel brought up so that we can make sure we're clear on the sequence of events that happened so that we can understand exactly what was going on in this particular situation. So we have on August 4th, 2020, and we all can recall the COVID pandemic and the issues that that created for many, many businesses. In particular, one of the most affected businesses and business models in this state and across the country were those of restaurants, right? And so many of those restaurants had to shut down for significant periods of time. And as a result of that, there were CARES Acts that was provided by the federal government, given to the state, that was then issued down to the counties in order to be able to administer on a local basis to help local businesses figure out what they could do to overcome some of the effects of the COVID-19 pandemic. On August 4th of 2020, the Nye County, including Commissioner Blundo, addressed the CARES Act issues. And in doing so, they said that they would allow for small businesses to apply for the CARES Act assistance on a first come, first served basis, and that all applications would be vetted through an internal approval process overseen by the Nye County manager and comptroller. And they took the entire process out of the hands of the Nye County Board of County Commissioners. There was going to be an outside party that was going to review these applications and grade them on merit. And then there was going to be, once they had given an approval, a thumbs up, thumbs down on the merit of these particular applications, then the comptroller and the county manager would do a final review and then issue out what they would have what's an agreement between the parties for how those funds were to be utilized and treated. That is the policy that was undertaken and continued to be the policy. And Commissioner Blundo made it abundantly clear that he was one of the affected businesses and encouraged other similar businesses to apply. In other words, treating himself equal to all other members of the public, saying he encouraged all of them to come out and apply for this particular funds. In the complaints, they specifically addressed three meetings that were at issue: the September 15th meeting, the October 20th, and the November 10th board meetings. At the September 15th meeting, with regard to agenda item 37, Commissioner Blundo undisputedly made a disclosure. Now, the question is going to come whether that was sufficient disclosure or not. That's what we're going to talk about later on. I just want to kind of go through the facts right now. The next issue comes on, but at that meeting, I want to make sure we're clear. District Attorney Chris Arabia, along with two district attorneys, were there. And so was the county manager, Tim Sutton, who is also himself an attorney and a licensed attorney. And so if there were deficiencies in those disclosures, there were opportunities for both the county attorneys and the county manager, if they viewed those to be deficient at the time, they could have provided any type of input. And Mr. Blundo has said that he was welcome to have any of those types of input. He welcomed them in those things. Commissioner Strickland moved to amend the policy at that point in time. Mr. Blundo seconded the motion. It passed unanimously. Similar occurrences happened during the October 10th with respect to item 441, again, making disclosures. Again, we had the attorneys and as well staff and the county manager present. And the same thing happened on November 10th meeting. One of the things that Associate Counsel has correctly stated is that he actually affirmatively made the disclosure at the November 10th meeting that he was utilizing the program. This is the exact quote: utilizing the program that we are setting policy for. So he let everybody know that his business was utilizing the policy that we're setting, that we're utilizing the program that they were setting policy for, made that disclosure, and then went ahead and participated in the item. And I don't think the participation in the item is under dispute as so long as the disclosure was sufficient. And it's our position that this disclosure was sufficient, or if it wasn't sufficient, then it would go to whether or not the sufficiency was intentional or willful. One of the issues that we come back to on this timeline is the fact that just prior, he had submitted his application, but just prior to the meeting, apparently an email had been sent out informing him that he had been a recipient of an award underneath the policy. And he didn't receive that email. In fact, if you look at the audit trail, you can see that there's no indications that it was opened or anything else like that. And so he goes in, and in fact, Miss Rucker, who was administering the policy, she actually states in her testimony that not only was Mr. Blundo, she didn't know whether Mr. Blundo was aware of it, but she herself wasn't even aware that he'd been approved yet because she hadn't seen the email yet, right? And so nobody knew what was going on at that point in time. She was there present at the meeting, and if she saw a particular issue, she could have easily addressed it with them at that point in time as well. But what happens at that meeting is something that becomes quite problematic. And I want to address this issue because this is something that I think is unique to this case. And the facts in this case will help support. So during this meeting, there is actually correspondence that's being taken through a chat that's going on between county employees. And this chat obviously can be requested through public records requests, and it was provided. During the chat, it clearly indicates that the county employees were in the process of setting Mr. Blundo up to violate or potentially violate an ethics law. And in doing so, they actually went ahead and allowed it to happen without providing any input to him or providing any assistance to him in those particular regards, when they knew or could have been able to help the county in that position. In fact, during Ms. Rucker's deposition, she was questioned about those exchanges. And she was asked, is it your duty and Mr. Sutton's duty to look out for the best interest of the county? Answer, yes. And is it in the best interest of the county to have commissioners that are actually acting potentially in violation of ethics violations? She says, I'm sorry, ask that again. And the question is it in the best interest of the county to have commissioners violating ethics rules? Well, no. Again, she was asked whether Mr. Sutton had an obligation to the county commissioners to assist them in avoiding potential issues such as ethics violations. And her response as the PMK for the county was, I would assume so, but I don't know. The issue here is that these people understood that there was a potential issue here and they weren't helping the county. They were setting up a county official for that. And I'm going to talk to you some arguments in part of my argument section, but we've now gone through the facts about why that's problematic. So the first legal argument, I want to dispose of a couple of the primary claims that are out there. The first claims are related to violations of 400 section 2, which is whether a public employee use their position to secure an unwarranted benefit. The commission reviews a public officer employee circumstances on a case-by-case basis to determine whether there has been an improper use of public position to seek or gain a business opportunity or private employment. NRS 281-402 defines unwarranted at the end. It says means without justification or adequate reason. So we look at what was the reason for the alleged violations. Here, Mr. Blendo had colorable reasons to apply on behalf of his business, and therefore whatever privileges, preferences, exemptions, or advantages he obtained were not unwarranted. In fact, they were warranted. He was applying just like anyone else to what was going to be overseen a process by third parties that were outside of his control. And I think that the associate counsel has admitted that there was nothing wrong with him even applying for the actual application, right? And so it wasn't the fact that it was an unwarranted or unjustified thing. It was for an adequate reason, and it was adequately disclosed, or at least attempted to be disclosed. It was disclosed, whether it was adequate or not, we will argue later on that issue. But there was definitely, it was warranted and justified, and therefore there should be no violation of 400 subsection 2. I think that can easily be disposed of, as that section can easily be disposed of based upon the admissions and the discussions of associate counsel, as well as the fact that what Mr. Blendo did exemplifies the fact that every person, regardless of their position title, would be subjected to the same process, and that he would not approve a process that he was not willing to undertake himself. There are no genuine issues of material fact, and so we would ask for judgment on that particular section. Again, with subsection 7 of section 400, the consolidated complaints did not make any colorable allegations that he used county time, property, or equipment to his own benefit. As we look through that, we're trying to figure out exactly what their claims are that he was using unwanted time or to his benefit. Yes, he entered into the building. There is a dispute as to what door he entered into. Okay, but there is nothing, and there are disputes as to also he did walk in and ask questions about that. And in the discussions with Ms. Rucker, she admitted that there were walk-ins that were permitted. It was preferred that people come in and make appointments, but that any member of the public could come in and walk in and talk to them about the application. And the other position is that, and I'll address this later, is that associate counsel talked about the fact that perhaps there was an abuse of some type of power by him coming in and doing this, or that caused other people to quit. One of the things you'll find is zero evidence of any person who has testified that they quit as a result of Mr. Blendo coming in or doing any of these type of actions. And I want to make sure that we're clear. It's specific to, were there anyone who, as a result of this policy or the implementation of this policy, who said, I was bullied and I had to quit as a result of that? And the answer is no. Nobody has provided any of that evidence because it doesn't exist. As such, it's very clear that the commission, that Mr. Blendo was not using government time or property, which the commission should find that if he did anything at all, it was limited in use, it did not interfere with his duties as a commissioner, and therefore would fall within the exception of the rule. Mr. Blendo did not secure any significant benefit that was not equally applied to all those similarly situated in Nye County. And his duty as a public officer was to assist in the development of the policy, which he did. And therefore, any of the allegations related to the 400 subsection 7 should be dismissed as a matter of law. Similarly, 400 subsection 9, this is that Mr. Blendo as a public officer should not attempt to benefit from any of anything. We can look at the conversations with the grants team following the November 2020. In the complaint, and this is one of the things we want to focus on as well, is the fact the complaint's really focused on these 3 meetings. Now we're getting into a lot of the events that occurred after the meetings, right? And that all came out as a part of discovery, but expanded the scope of the complaints that were before this particular body. However, if the commission does want to consider the actions or communications that occurred after the time period in which the complaints were affected, the commission should not find that Mr. Blendo's actions violate this particular subsection. He was within his rights to inquire about the application status of his restaurant, just like any other member of the public, regardless of his position or title, and to be treated the same as any other applicant who was welcome to do the same. Any other applicant could walk in. It was preferred that they set an appointment, but anyone could walk in. The only question, and if there was a misuse of anything, it's the allegation there was a misuse of him using the back door, which is disputed. Whether he came in the back door, he came in the front door is an issue of dispute. And that would be a material fact in particular if it was an issue at all, although we don't believe it to be an issue because it's not substantial. And there has to be a substantiality to this particular effect. Finally, there's no contention that a subordinate was unduly influenced by Mr. Blendo or his position as county manager. Again, there is no evidence other than we have testimony from somebody who, as a part of their hearsay, was saying, well, we think people quit, but there was nothing that ties it to this particular issue. If somebody quit, it would have been incumbent upon the executive director as a part of the discovery process to go and locate that individual. All it would have taken was during the deposition to ask the question, who quit? Go take their deposition. Did you quit because? And then that would have been that, but that wasn't the burden that they didn't assume that burden. They didn't take that burden, and they haven't met their burden with respect to this particular subsection 409. And therefore, not only is it an issue, is it, as Mr. Blendo entitled to it as a matter of law, a judgment on this particular section, there's been no facts that have been adjudicated or proffered by the executive director with respect to support any claim at all underneath this particular subsection. Now to get to the subsections that I think are really the meat and potatoes of this particular case. Those other subsections I think can be easily disposed of. What we're talking about here are going to be those of 421 or 3. The first one is I want to take subsection 420, subsection 1. This is whether this subsection addresses primarily the disclosure and abstention requirements, right? Here, Mr. Blendo was a Nye County commissioner at the time of the events in question and does not deny that he voted on these particular items. He also, and as readily admitted, and as readily evidenced by the record, attempted to make a disclosure at each one of these particular instances. So the issue comes back as to whether those disclosures were sufficient. At the disclosure in particular issue, which was the November 10th motion, in agenda item, he specifically disclosed, I am utilizing the programs that we are setting policy for, end quote. Again, we believe that this was sufficient, particularly the fact that the commission defined significant pecuniary interest to mean is, we believe this is a sufficient disclosure. Additionally, one of the things that the commission, let me go back. So the commission reviews facts of each case to determine whether there's significant nexus and whether the beneficial or detrimental between the manner and considers the private interest of the public officer and employees. So again, we look back and we say, in making sure that this disclosure is sufficient, we need to look and see what was being undertaken, right? And is there that sufficient nexus? Was this a sufficient disclosure to advise the public as to what was being undertaken by the commissioner? He was very clear. I'm about to vote on policy that is related to the CARES Act. That's what they were. That was the item. It was properly noticed. Nobody's questioning that. And he says, I'm utilizing this program. I didn't say his business is anything else. I am utilizing it. He was very clear. I'm utilizing that for the programs that we are setting policy for. He made that disclosure. It was sufficient so that anybody who was there would have been able to identify that he had a vested interest in what was going, potentially a pecuniary interest in what was going on. But his pecuniary interest, and we'll talk about that, was not that different from any other member of the public. He was going through the same exact processes that we're going to be going for the rest of the public.
Mr. Hardy,
yeah.
did Mr. Blendo utilize all of the programs discussed at the meeting?
No, In that particular, well, at that particular meeting, the issue was related to, that particular agenda item was related to increasing the amounts under different levels of the program, right? And so he wasn't a participant in all levels of the program. He was a participant in a single level of the program, and he was seeking to have, during that time, they were voting and considering whether increases under the level of that program would be appropriate. So the answer is yes and no, right? Yes, as a total of the part of the program, he was applying, but only for a subsection of that because there were tiers. If you were at this tier, you'd move to that tier. During this tier, you'd move up and those amounts would graduate. So he was within one of the applicable tiers. Does that make sense?
Yes, thank you.
So as we go through, he does vote on this particular issue, but he makes the appropriate disclosures. I want to make sure that during that same meeting, if the county staff who was aware of the application, and if the county manager who was aware of the application, and the public were aware of the application because he made the disclosures, they were fully aware of that. And the district attorney, if there were concerns about that, and Mr. Blundell says that he often looks to the district attorney and has even made a request to the district attorney at different points in time on the sufficiency of his disclosures. If there was a concern, we would have asked, look, let me know. And in fact, what we see from the text messages is that they decided, nope, it may not be sufficient. And they begin texting about how they're going to set this up and not disclose, not help him out, not do anything, and set him up so that they can make, as in their own words, we can file an ethics complaint. And in their own words, I'll file my own too. So now they're going to get 2 ethics complaints as a result of these particular issues. This is one of those issues where I'm going to provide an analogy over to the criminal law. And I understand that there's the issue of entrapment. And I know that this is a kind of a new and a novel concept for the Ethics Commission. It's not something that you guys generally address or look at, but I think there's an analogous issue here that creates some precedent if this particular decision is rendered against Mr. Blundell, and that we can now have staff members affirmatively setting up or entrapping members of the commission or otherwise by withholding relevant information and utilizing that to their benefit in order to advance their political agendas or their other types of things. In fact, as we know, entrapment typically deals with criminal law. The commission should find that the rationale and policy considerations behind the entrapment defenses are also applicable here. In Foster, which is cited in our briefing, the court explained that the purpose of entrapment defense is to deter governmental misconduct. And similarly here, it's exactly what this commission does. They deter governmental misconduct. And one of the things that you're looking to do is deter governmental misconduct. You can't go out and affirmatively let people in government begin setting up traps or entrapment of other governmental officials. That is not something that I think we want to be fostering as an organization. I don't think the commission wants to be fostering that type of behavior. Instead, they should be working together through training and otherwise to be able to make sure everybody understands fully what's going on. And they're doing a great job with that, by the way, Ross. You guys are doing a great job in training. But we believe that the commission should look that Mr. Blundell did not violate subsection 1 of 420. Finally, with respect to subsection 3 of 420, this details the abstention requirements. We believe that, and I think that Associate Counsel has indicated the fact that if the disclosure was sufficient, then he did not need to abstain. And so we believe that the disclosure was sufficient, but if it wasn't sufficient, it was not willful, and any abstention that would have been required thereunder because it was not willful should be taken into consideration as well. Again, public policy disfavors abstention. And in fact, when you review subsection 4B, it talks about abstention by a public officer disrupts the normal course of representative government affairs and deprives the public of the public officer's constituents and a voice in governmental affairs. And he was in particular representing businesses just like his that had an interest in making sure that they were able to participate fully in the COVID relief plan that was undertaken. With that, I think that Mr. Blundell is entitled to adjudication on all of these claims. And I think that at a minimum today, he's entitled to adjudication on substantially all of these claims. If there is a discussion at all to be had, it should be on whether or not the disclosure was sufficient, and whether that would mean something with respect to willful, which would be an issue of fact, which would be precluded to be determined on a motion for summary judgment. Thank you.
Thank you, Mr. Hardy. At this time, I will open it up for questions from fellow commissioners about this case. And if you need to, we can meet with our commission counsel in private for legal issues. Oh, one more time, sorry. Okay, it's okay.
I'm also happy to answer any questions. If people have questions at this point, I'm happy to answer them as well. I'm going to try to kind of take this in order. First, I'd like to address the alleged violation of 400 subsection 2, which the executive director has not moved for summary judgment on. Summary judgment is not appropriate as to that violation. The commission's previous opinions are clear. You review that on a fact by fact, case by case basis, which makes it not appropriate for summary judgment. Whether or in fact he had received an unwarranted benefit, sought one, is a question of fact, and it's not appropriate to be dismissed or summary judgment to be granted on that point at this time. I'd like to also address the discussions of the responsibilities of the county attorney who was sitting in the room, who happens to be a lawyer but does not need to be. He just happens to have that educational background, as well as the other county staff. As this commission knows, it's the motivations of the requester or the behavior of other people are irrelevant to whether a subject violated the ethics law. No one in the room, there was no action on the part of anyone in the room that caused Mr. Blendo to violate the ethics law. In fact, he's the one who proposed increasing the funding limits for the program, which then caused him to have the responsibility to disclose. There was no setup. Entrapment is a defense, it's a criminal defense. It doesn't apply here. And it's meant to prevent the state from overstepping its authority in dealing with criminals. Here, Mr. Blendo participated in the item. He suggested increasing the funding limits that caused him to then have a responsibility to make a disclosure. That was not caused by anyone else, nor can his failure to comply be blamed on anyone else. He has a requirement to know what the ethics laws are, what his ethics disclosures must be. And in fact, he's had other issues before this ethics commission, as you know, and in those matters, he's been told he has a process. He can go seek an advisory opinion. There are ways for him to find out exactly what his disclosure needs to be if he's unsure. He also, there's discussion of the district attorneys being in the room. Mr. Blendo provided no evidence that he ever sought any information from the district attorneys. We do have a safe harbor rule. Had he sought that information, he could have used that as a defense to the willful versus non-willful. There's no evidence that he sought any information from them. There's also no evidence those district attorneys had any idea of the extent of his involvement with the programs. He did say he was utilizing them, but because he didn't make the sufficient disclosure, nobody in the room could tell him whether or not he needed to disclose more or less, nor did they have a responsibility to do so. It's solely Mr. Blendo's responsibility to make sure his disclosure meets the ethics requirement. It's his ethics requirement, not anyone else in the room to tell him how to disclose. He could have sought that information in advance, knowing that this agenda item was on the commission's meeting, and also knowing that he had applied, but he did not do that. He is not alleging that he got that advice and that he was told how to disclose. Oh, yeah, and this goes to turning to the disclosure. We don't have a dispute as to the wording that was used. I think everyone agrees it's on video. It's very clear. We can see the recording. We know exactly what Mr. Blendo disclosed. The question is, was it sufficient or was it not? When Mr. Blendo said he had no pecuniary interest in the matter, that was a misrepresentation. He absolutely had a pecuniary interest. He's the sole owner of his restaurant. He owes it a private commitment in a private capacity, and he absolutely therefore had a pecuniary interest imputed to him through that restaurant. So his representation that he had no pecuniary interest was not sufficient under our law, which requires that the disclosure provide enough information to the public that's sitting there that they can determine how what the effect of voting on the agenda item and how it's voted on is going to affect the interests of Mr. Blundo. He did not indicate he had applied under this program. He did not indicate that an increase in the funding limits under that agenda item would mean an increase in money that would go to his business and to him. That isn't sufficient information. The law here is clear, that the commission has looked at in the past, is that you have to make it sufficient that the people sitting, the public who are watching on the video, who are sitting in the room, know exactly what the interest is. Just saying, oh, I'm utilizing these programs without specifying what program and in what way, that he had a pending application, and I would argue the documents do show it's a DocuServe document. It shows it was opened by Mr. Blundo prior to the meeting, but even if it hadn't been, doesn't matter. He knew he had a pending application. He needed to disclose that. He needed to disclose, but by voting to increase funding limits, that would mean an increase in money to him and his business. And then when you follow, I'm sorry.
I have a quick question on the direct pecuniary interest language. My understanding, and correct me if I'm wrong, either party, Mr. Blundo owned an LLC called the Hole in the Wall LLC, which in turn owned the restaurant. Is that a direct link?
Yes, he's the sole owner. So any funds that go to that company are only imputed to him. I would argue that is in fact a direct pecuniary interest.
Mr. Hardy, any thoughts on that?
He is, there is no dispute that he is 100% owner of the business, and therefore he would be, as the business owner, a beneficiary of that money. There's no corporate shield in these laws, so thank you.
Turning to the discussion on 407 and 9, the use of government property and the influence of subordinates. There is testimony from Ms. Rucker on this issue that he did insist on special treatment. In fact, the testimony was that if members of the public had acted the way he did, they would have called the police. So the issue is it wasn't that you could just stop by and get help, and that's what he did. They required appointments, and the testimony is if a member of the public had come in like he did, number one, the police would have been called. And number two, they would not have been, his issues wouldn't have been addressed right then. They would have helped him if they could, but most likely would have insisted they make an appointment. But the feeling among county staff was because Mr. Blundo was the county commissioner and the way he behaved, they had to help him right then. He would walk into their offices, like into people's offices and ask them questions about his applications, insist on getting help. That is clearly not help that is available to members of the public. He was not availing himself the way a member of the public would. He was using his public position to go through a back door and insist that county staff give him special treatment. And the comptroller did testify she lost multiple staff members as a result of the behavior of Mr. Blundo that made her staff feel intimidated and upset. She had to lock the door. She had to ask him, it's undisputed. We had discussed it with Mr. Blundo on the record. He was asked not to come back to the county offices and only to deal with the comptroller because of the way he behaved in the county offices. I think unless you have a further questions on anything that addresses.
Commissioner Yan.
Commissioner Yan.
Have you guys both concluded your arguments? I just want to make sure.
No, we have to call back on Mr. Hardy.
Oh, okay, you're getting the reply, Mr. Hardy?
Yes,
Okay, all right, I'll wait. I'll see what you say.
thanks, Commissioner Yen, and happy to answer any questions you have preemptively as well, so.
Yes.
We are the party who moved for summary judgment on subsection 2. And I understand the executive director didn't do that. But what you've heard today are multiple admissions that there was not an unwarranted reason for him to seek particular benefits here. I mean, even that's been admitted by the associate counsel today that, hey, there was no problem with him applying. It wasn't unwarranted. And he wasn't using his government position to do that. And so we've sought summary judgment on that because it was not something that was unwarranted. I understand that these are often taken on a case-by-case basis, except when the fact we have an admission that it wasn't unwarranted, right? That it's not unwarranted. In fact, every eligible business, it's undisputed, in Nye County was invited to apply to the programs, and Blundo hoped to lead by example by openly encouraging others and had told them he would engage in the same process that he expected of every other member of the public. It was not unwarranted. He undertook the same exact processes that everybody else did. So I want to be clear that we were the ones seeking summary judgment on that and adjudication on that issue because we believe that at this point in time, it is appropriate. The same way with section 7, which I know that we've discussed, and subsection 9, we believe those should be disposed of as a matter of course at this point in time because there's just no support for any of those issues. Again, I think this comes down and it boils down to the sufficiency of the disclosure, which is going to be the 421 and 3 sections. That's what I think this whole entire case should boil down to at the end of the day. And when we look at those particular issues, we can look at the disclosure. It is undisputed, and I agree with Associate Counsel. It is undisputed that he stated that he had he stated that he was utilizing the programs that we were setting policy for. And that was a definite part of he admitted, I am going to utilize the programs that we are talking about today. I'm actively utilizing. He did. And not only that, but they were aware of that. Right? He'd openly talked about it if we go all the way back to the August when they first voted on this, he told everybody that he would be applying for these particular programs and encouraged others to do the same. This was a consistent theme of his that he knew and was going to be able to disclose to people all the time. I'm doing the same process that you are. Come in. And the reason that he was inviting everybody to do that, I want to go back, is because these funds were use them or lose them funds. That the county had to utilize, and this is all part of the testimony of Ms. Rucker, they had to utilize these funds by a certain date or deadline, or else they risked losing them back to the state and then to the state and utilize them to the federal government. And so the county had an incentive to make sure that all of these funds were used by a certain time period, which is why as they got applicants coming in, they decided, you know what would be prudent to do? Let's increase the amount because based upon the number of applicants we have in and the amount of funds we have to give out, we need to be able to get more money to the applicants that are actually care about this and want to apply. That's what this was all about. It wasn't an unwarranted or unjustified amount. It was something that he was looking for the benefit of all applicants. He didn't know at that point in time whether his application was or was not approved. He was simply advising that he was utilizing the program. And again, with respect to the entrance and where he entered at issue, this is something that is a disputed fact, right? Mr. Blundo's position is that he came in and he talked to a staff member. The staff member then walked him over to Ms. Rucker's office, right? And so Ms. Rucker's recollection of him walking in through a back door isn't, she may have believed that he came in through a back door. He is positive the opinion that he walked in, talked to an assistant, and that she then brought him to Ms. Rucker's office. And so that is his, and so if that's a disputed fact, it seems to be material. I don't believe it to be material because it's not a substantial use of government resources or anything else. It's not any of the other things that would meet the elements of this, but I want to make sure we're clear exactly what the testimony was on that. And again, I go back to the final thing is that there was never an employee that has been identified with specificity. Again, this is not Mr. Blundo's burden. This is the executive director's burden to establish that there was a singular employee who, as a result of this conduct, quit. We'd love to see the identity of one of those people. We'd love to hear the testimony of one of those employees. We'd love to be able to see one of them testify that I quit because of this issue, but it's never happened. And for that reason, we're entitled to adjudication on that issue. Thank you.
Right. Now, I will go ahead. Thank you very much. I will open it up to my fellow commissioners for questions. Commissioner Yen.
Yeah, I have a couple of questions. You guys did a really great job though in arguing, as I had about a page of questions and I'm down to just a couple, so I appreciate it. Associate Counsel, let's see, Bassett, I do have a couple questions for you on 402. I know you guys did not move for summary judgment, but you made a couple of statements. You said you didn't move for it because it's always a question of fact. So you can never grant summary judgment even if there's undisputed facts. Is that what you're saying?
Not necessarily. I think there are instances in which summary judgment may be appropriate on this, on that code section, depending on the facts of the case. However, I think this commission has generally taken a look at those on a case-by-case basis. There's not a lot of standards out there for exactly what violates subsection 2. And even in arguing here today, it's clear there are different ways to view that statute. The way I read it is it says that the public officer use their position in government to secure or grant unwarranted privileges, preferences, exemptions, or advantages. You know, Mr. Hardy's arguing, well, Mr. Blendo had a right to apply for the funds and therefore it can be unwarranted. But I would argue it unwarranted could also mean the way he went about applying, the way he went about obtaining those funds. I don't think it's just the end result, but also perhaps his process and his behavior, whether that was unwarranted as well. So I think there are instances where it might be appropriate, but I definitely don't think this is one of them. There are too many disputed facts about what that process may have looked like and whether it was unwarranted or under the definition of our law.
Okay, well, I'll let you know that I was leaning towards granting summary judgment in your favor, even though you didn't move for it. Because I think that we have the ability and right to grant summary judgment in someone's favor, but you are talking me out of it, telling me no, that we shouldn't grant summary judgment for 402. But I'm gonna ask 2 questions just to make sure I feel comfortable with that. So first, it's undisputed that he had applied at the time of the November 10th meeting for the CARES Act, correct?
Correct.
There's a dispute as to whether or not he knew his application had been granted, but Mr. Blendo did know that he had applied, because he was the one who applied for it. So if the position is, and I'm going to just say that he didn't do a proper disclosure. Let's just assume for purposes of 402 that he did not do a proper disclosure, and we know he didn't abstain. In Ray, Public Officer 21, I think you guys cited it, 21-101A states that if a public officer uses the government position to grant unwarranted privileges, preferences, exemptions, or advantages, any circumstances that would otherwise support abstention, any action to the contrary would be construed as a misuse of a public position to provide an unwarranted benefit. So my question to you then, if it's undisputed that he knew he had applied, and it's undisputed that he knew that if he was voting for the increase and he would get an additional $35,000 and he did not properly disclose, let's assume that for this question, properly disclose and abstain, would that be unwarranted such that summary judgment could be granted on 400 subsection 2?
If I can address that, Commissioner Yen.
Can I get Associate Counsel Bassett, please, first?
I think in that instance, and like we cited in our briefs in this matter, that does go to like I said, the process as opposed to the end result. Was it unwarranted for him to fail to disclose and then fail to abstain? And this commission has issued an opinion that states exactly what you said, that if there's a failure to abstain and there would have otherwise been a requirement to abstain, that is a violation of 402, which is the process, which is again, like the process. Yes, he had a right to apply, but did he have a right to go about engaging in the process in the way he did as a public officer? So I do believe, as I stated, that is one of those exceptions where the question isn't was the end result unwarranted, but was his process in seeking the end result unwarranted. And I do think there is an agreement here that the disclosure is what it is. And so then it would be undisputed if the commission wanted to find that abstention was required, then I do think it is an instance in which 402 summary judgment could then be granted.
Okay, thank you. Yes, Mr. Hardy.
Yeah, so Commissioner Yen, I want to make sure that we're very clear on subsection 2 on what it reads. The unwarranted section that we're referring to only refers to, and it states, privileges, preferences, exemptions, or advantages. It is not unwarranted with respect to behavior, because the behavior is the preface of that particular sentence, right? So it's not talking about behavior like Associate Counsel continues to reference. It is to see whether that benefit that he received was or was not unwarranted. That is the causal connection here. It is not looking at behavior. It is not looking at those particular things. It is looking at the benefit. Was that benefit unwarranted? In fact, if you look at the very end of that of subsection 2, it states, as used in this subsection, unwarranted means without justification or adequate reason, right? And so does he have a justification or an adequate reason for what he was seeking? And the answer is yes. He, like all of other applicants, and he didn't know whether he had or had not received or been able to be granted the application yet, was you had a justified means to say, we have two reasons. One, in my position as a public officer, we have to utilize these funds now or we're going to lose them. And the way that we can do that is by increasing the amount for all candidates, not just himself, but for anybody who's applied in this particular pool of people. And so everybody is going to benefit by this. But he does make as a part of his disclosure. And I know we're not going to talk about the adequacy of the disclosure, but he does say, I'm a participant in this process. Okay, so the question is was it without justification? That's what the unwarranted means, right? It's very clear in the statute what it says. And he had adequate justification, both in his capacity, in particular in his capacity as a public officer. It was warranted to be able to increase. He had a justification. He had a job to do. Otherwise, the county and the county residents were going to lose this money. And so this was something that was definitely warranted and justified, and his actions were appropriate in that particular, which means that in this particular case, summary judgment adjudication on 402 should be granted in favor of Mr. Blundo.
So is it your position, Mr. Hardy, then that does disclosure ever come into whether something's warranted or unwarranted?
Does disclosure,
Taking into consideration in Public Officer 21-101A. So I just want, so, you know, we're not going to talk about the disclosure. So now for purposes for your answer, let's say the disclosure was completely proper. So now would it take it outside of being quote unwarranted, or if the disclosure was improper, would it say now it's not warranted? Does disclosure come into 400 subsection 2?
It does not, because what we're looking at with subsection 2 is only the benefit, right? What you're looking at here is, did a public officer receive an unwarranted benefit? That's it. And so then we look at what the unwarranted is, and you look further on and it talks about being either justified or with adequate reason. And in this particular case, it's undisputed that nobody disputes the fact that these funds were gone if they didn't do something with them, right? And so it was justified and it was warranted, and we're only looking at the result and we're not looking at the behavior. Or
So
the disclosure, sorry.
So the last question, I don't want to beat this dead, but my last question. So how would you reconcile that with In Re Public Officer 21-101A?
Yeah, so what we're talking about there is again, we're looking at two different things. You have to look and say, first of all, this is a precursor to whether you're going to have to, whether a disclosure is going to be sufficient, right? So the first thing you're going to look at is what we're about to do. Is it going to now, is it going to be unwarranted or unjustified? If it is, now I have to go back to my disclosure and look at that to see what is going to be a sufficient disclosure, or can I make a sufficient disclosure on this issue? And then they make the best disclosure they can. And then they look to abstention and say, do I have to abstain? Can I do? This is part of that preliminary process. You got to look at the unwarranted first to find out whether your disclosure is going to be adequate or not, or sufficient access to the unwarranted privilege.
Okay, so then with what you just said, if you look at the benefit and you say it's warranted, then you don't have to disclose. If you look at the benefit and it's unwarranted, then your position would be you have to make a proper disclosure. And
not necessarily, because you may, if there's a benefit at all, you may have an obligation of disclosure, right? But you're going to have to find out what becomes sufficient disclosure. And that's the key for this entire thing, right? Is, hey, you may get a benefit that's warranted, or if it's an unwarranted benefit, you'd better abstain from the whole process, right? If it's warranted, then we need to look at the sufficiency of the disclosure. If you're going to get no benefit from it, then perhaps you don't even need to make a disclosure, right? And so we need to look at this warranted or unwarranted first to decide disclosure and where we need to move from that point, what that disclosure needs to be encapsulated in, and how you would proceed forward. And that's why we look at this at the preliminary basis and say, was this something that was unwarranted? The answer to that is undeniably no. It was not unwarranted underneath the definition provided in the statute, which is why we're entitled to summary judgment.
So I'm good on 400 subsection 2, unless another commissioner has any questions, and I could move on to mine, but if anybody wants to talk about 400 subsection 2, I'll pause.
I have a question. Just to kind of ask the flip side of what we've been talking about from Ms. Bassett, I think you had stated that if Mr. Blundo had made a proper disclosure, he would not have been required to abstain. Is that correct?
For purposes of argument today, yeah, I mean, he had to go through the abstention analysis.
Right.
That didn't happen here. So I'm not substituting my argument today for that abstention analysis. He would have been required to do the abstention analysis. But for argument's sake today, my argument is he was entitled to go forward with. He was entitled to apply for the funds. He was entitled to take part in the process like any member of the public. Whether we would look at that abstention analysis and say he did or didn't have to abstain, I can't be certain because that didn't occur, and therefore it's a violation by not properly disclosing. He cannot properly abstain. That's the way the law works. I don't disagree. There's a possibility he may not have had to abstain. He was in the same position as other people, other businesses, but it's not clear until he went through that abstention analysis, which he didn't do.
And just as a follow-up, if the commission were to find, the disclosure was proper and he wasn't required to abstain, wouldn't Mr. Blundo still be liable for a violation of 400 subsection 2?
I believe that would have to be looked at on from a factual basis, yes.
And just to add one thing, through the chair, sorry. So, but just to address that particular issue is the fact that the allegation that there was no abstention analysis done, I think is inappropriate here because in fact, he did to make the analysis and say, after my disclosure, I'm now going to participate, and he did. So to say that analysis wasn't run, I think is inappropriate. He did make that decision not to abstain. There was an analysis that was done based upon my representation, but I think I did an adequate disclosure here. I'm going to proceed forward. So to say there wasn't an analysis, I think is inappropriate. What I think would be more appropriate to say she disagrees with how that analysis outcome resulted, but perhaps not, right? I think she said that, well, if it was a sufficient disclosure, he could have participated, right? So there's not whether there was or was not an analysis, because there was. He made the analysis and made the determination to proceed.
Madam Chair,
Yes, Commissioner Oscarson.
I just have one question, and I don't know who to direct this to because I'm not a legal person, but the one thing that continually sticks out in my mind is the fact that in his testimony, he stated, "I don't have a direct pecuniary interest in this policy." Even after saying he's utilizing programs, and that's documented on the videotape. You guys can look up the number. I can give it to you if you want. And then he goes on to say that operating for 14 years, believe his experience is valuable to participating in this, so I will be participating. So my concern is, regardless of any of these other things that we're talking about, it's like a double thing that he said he disclosed, but he did not. I don't have, and I quote, "don't have a direct pecuniary interest in this policy." So what does that say? I'm for me, it's pretty clear, but certainly I'm open to discussion.
Would you like that addressed, Commissioner Oscarson?
That's kind of the way I feel, unless somebody can tell me differently.
If I can address just one of those issues, what we have to look at is the totality of the disclosure, right? And when we look at the totality of the disclosure, he states that he was utilizing the programs which we were setting policy for. He made it abundantly clear, I am utilizing these policies. But then he says, I don't have a pecuniary interest. You got to remember, he doesn't know whether he has or has not been granted funds underneath this particular policy at that point in time. He doesn't know. As far as he knows, he hasn't been any pecuniary. He has no pecuniary interest in it, other than the fact that he has admitted in his disclosure that he's utilizing the program. Right at this point in time, you got to look at it at the point in time in which the disclosure was made, and he's stating, "I'm utilizing the program, but at this point in time, I don't have a pecuniary interest because I've never been granted my application." I mean, that's what you need to look at, is the totality of the statement of what he made. And this, I think, was a sufficient disclosure given the circumstances at the time.
Council Bassett.
I don't disagree. You have to look at the totality of the disclosure, and here, what he disclosed to the public was he did not have a direct pecuniary interest. Whether or not his application had been granted yet, he still had a pecuniary interest in the policy. He had applied, whether he knew or not, which is disputed, he knew he had applied. And he knew he was waiting a decision. He also at that moment in time knew that not many people had applied and not many funds were being distributed. So even with that knowledge, looking at the totality, that actually, you know, I think goes against his favor, because at that point they were raising the limits because they didn't have enough applications. He knew he had a pending application. He knew a rise in the limits would mean more money for his business, more money for himself. When you look at the totality of the disclosure, you have to look at the fact that he said he didn't have a pecuniary interest. That's a very specific thing to say. It told the public he didn't have a financial interest in this agenda item, when he absolutely did have a financial interest. Whether that application had been granted yet or not, he had it pending. He knew he potentially was asking the county to provide those funds to his business and to himself. So looking at the totality of the entire disclosure, it's not sufficient. He says, I'm utilizing programs. He doesn't specify what the program is. He doesn't specify he's made an application on behalf of his business. And then he says he doesn't have a pecuniary interest, which is absolutely not true. And so I would argue it absolutely is not an adequate disclosure under the ethics law rules and the previous opinions of the commission.
And in response, Madam Chair, one of the things that I agree with 100% with the associate counsel. You look at it in its totality. He knew he had applied, which is exactly what he said in his disclosure. I applied. I am utilizing the programs. And she said it wasn't sufficient. He said that we are setting policy for, very specific. On this item, I'm utilizing these programs. I'm one of the people that's utilizing this. But at this point in time, I don't know what's happened. So I have no direct pecuniary interest in this. Because I haven't been given anything. That's the disclosure he attempted to make. Now, whether it was sufficient or not, but there can be no question at this point in time that he was trying to make a disclosure that addressed all of these particular issues. Thank you.
I would argue to that a misleading disclosure can never be a complete disclosure. A disclosure that misrepresents the public officer's interest in the item cannot be a sufficient disclosure. And Mr. Blando did not say he had applied for the program. He did not say he had a pending application. None of those things were in fact said. He said he was utilizing programs they're setting policy for. They were setting policy for numerous programs, including PPE reimbursement, all kinds of things that were not $50,000 directly to a business and therefore to Mr. Blando. So, you know, that disclosure did not provide the public with the level of information that our ethics law requires a public officer to provide on an item they have a conflict of interest in.
All right, I think we hashed this one out a lot. Okay, other questions on other sections from my commissioners? Commissioner Yin.
Yeah, so I would like to go to 400 subsection 7. And this is for whoever wants to answer this, because I looked through everything, but outside of Rucker, I didn't see anyone else stating that Blando walked through the staff door. Was there other evidence beside Rucker's testimony?
No, that's the testimony.
Okay, let's see. And then for 400 subsection 9, was there any evidence, and because I couldn't find a lot, that Mr. Blando directed county staff to take an action that they were unwilling to take?
No.
Was there any evidence that Mr. Blando made statements threatening any county staff, including through violence or retaliation?
No. In
Was
fact,
there,
when she was asked specifically about it, Ms. Rucker said that she didn't have any specific statement she could identify.
was there any evidence that Mr. Blando's request for a review of his application was different from any similar requests made by the members of the public?
Yes, there's testimony from Ms. Rucker on that point repeatedly in her deposition.
But I'm saying, besides that she felt that he was, his tone, was there any statements?
No.
Let's see. I think you guys answered that. Give me 1 second. Associate Counsel Bass, you've already, I think you stated in your argument that the public is not precluded from interacting with staff on the application or business, and the public's not precluded from making phone calls to the finance office, correct?
Correct.
I don't have any more questions.
Okay, Commissioner Lowry, do you have any questions?
No, thank you, Madam Chair.
Commissioner Towler?
No, I had four, but they were all answers.
Some great questions going back and forth.
Yeah, I mean, it's a very complicated issue here. Our commission council would like to have us go in. You want to still do a private legal talk, or do we need to? I don't think so. No, I don't think we need to do that now. Yeah, I think a lot of my questions. Oh, Commissioner Yin?
Oh, no, I was sorry. Sorry, Chair. I was just ready to make a motion.
Okay, yeah, a lot of my questions that, I was letting my legal colleagues ask first. They got answered. Okay. And so Commissioner Yin, I will entertain a motion.
Okay, so I will just say before my motion that I was leaning towards granting summary judgment, as I said, in the executive director's position for 400 subsection 2, but I'm going to listen that this is mainly for questions of fact. I don't see it here. So I'm just going to let you guys know how I feel as you go into deliberations and work a stipulation and try to get the rest of this settled later. So my motion would be the commission's reviewed the entire record for this matter. We've considered the briefing and the arguments of counsel. And I would move to deny summary judgment on NRS 281A.400 subsection 2, and that claim would be still outstanding. I would deny summary judgment on NRS 281A.400 subsection 7, as I believe that there are questions of fact remaining. I would deny summary judgment on NRS 281A.400 subsection 9, as I also believe there are disputed facts. And I would grant summary judgment in favor of the executive director on NRS 281A.420 subsections 1 and 3.
I would second that. This is Commissioner Lowry.
Just to add to that, if the motion could also include whether or not counsel for the commission will prepare the order in coordination with the chair or collect the determination of the commission.
So amended. Thank you.
And I second that.
Right. We'll go ahead and take a vote. All those in favor? Say aye.
Aye.
Opposed? Motion carried. Right. Thank you very much. Thank you for your assistance with our staff, and
Thank you for your time,
yes, thank you.
commissioners.
We need a little bit of a break here. Okay.
Take a 5-minute break, 10-minute break.
10 minutes.
10-minute
10 minutes.
break.
People have time to get coffee, water. All right. Fellow commissioners, we're going to go ahead and get started. I don't see Commissioner Lowry, Commissioner Oscarson. There's Commissioner Oscarson. Right, Commissioner Lowry should be back here shortly. Right, now we move on to item 5, hearing on depositive motions in case number 22-051C regarding Joseph Rodriguez, trustee, Washoe County School District, Lieutenant State Fire Marshal, State of Nevada, including providing authority to the Vice Chair of the Commission to prepare and issue the order reflecting the Commission's decision and other matters relating thereto in consultation with counsel for the Commission. Vice Chair Dufferin will be the presiding officer for these proceedings. Vice Chair Dufferin.
Thank you, Madam Chair. Do we have any disclosures for this item by any of the commissioners? I see Commissioner Yan.
Yes, in compliance with NRS 281A.420 and judicial canons applicable to me as a quasi judicial officer, I am disclosing that I am a partner with the law firm of McDonald Crono, of which Mr. Rodriguez is a client. Therefore, pursuant to NRS 281A.065 subsections 4 and 5, I have a commitment in a private capacity to my law firm and the client based on my law firm's continuing business relationship with that client. Consequently, the independence of judgment of a reasoned person in my situation could be materially affected by the conflict in participating and voting in this matter. To avoid conflicts of interest and any appearance of impropriety, I am disclosing the conflict and will be abstaining from any participation on this matter. I have consulted with Deputy Attorney General St. Jules, who agrees with my disclosure and abstention in this matter. Thank you.
Thank you, Commissioner Yan. Any other commissioners have any disclosures to make? Seeing none, proper notice has been provided and waivers have been received for ethics case number 22-051C. Further, the members of the review panel, Chair Wallen, Commissioners Towler and Sheets may not participate in the consideration of these dispositive motions pursuant to NRS 281A.220 subsection 4. Commissioner Yan has just abstained and she will not participate in positive motions. All other commissioners may participate and vote on this matter, which leaves myself, Commissioners Greenwald, Lowry, and Oscarson. And I'd like, just before we get started, make sure that when you speak, make sure the court reporter knows who you are so that she can record this effectively. Just state your name. So let's start with that. Counsel for both parties, please identify yourselves and your clients for the record. We'll start with the executive director.
Good morning. I'm Elizabeth Bassett, Associate Counsel for the Commission on Ethics, representing the Executive Director today.
Good morning, Adam Hosmer-Henner, McDonald Toronto, on behalf of Trustee Rodriguez.
Joe Rodriguez, Trustee Washington County School District.
Thank you. We have two dispositive motions for the commission's consideration. For presentation purposes, Ms. Bassett will first present argument on the executive director's motion for summary judgment. Second, Mr. Hosmer-Henner will present argument on Mr. Rodriguez's response to the executive director's motion for summary judgment, as well as on Mr. Rodriguez's motion for summary judgment. Third, Ms. Bassett will present argument on the executive director's reply in support of the motion and on the executive director's opposition to Mr. Rodriguez's motion for summary judgment. And fourth, Mr. Hosmer-Henner will present argument on Mr. Rodriguez's reply in support of his motion for summary judgment. So let's start with Ms. Bassett. Please present any argument on the executive director's motion for summary judgment. Thank you.
Thank you. Good morning. For the record, I'm Elizabeth Bassett, Associate Counsel. This matter concerns the conduct of subject Joseph Rodriguez. Mr. Rodriguez is a lieutenant of the Nevada State Fire Marshal Division. He's also a trustee of the Washoe County School District. Mr. Rodriguez is therefore both a public officer and a public employee. Mr. Rodriguez was initially appointed as a school district trustee in 2021 and subsequently ran for and won re-election to his seat in 2022. An ethics complaint was filed alleging that Mr. Rodriguez violated the ethics law during his campaign by using his State Fire Marshal Division uniform, badge, and gun in pictures to campaign for his trustee position. The complaint also alleged a number of other ethics violations against Mr. Rodriguez, the rest of which were dismissed for lack of sufficient evidence. This is the only remaining, these are the only two remaining alleged violations. The executive director's investigation showed that Mr. Rodriguez posted pictures to his campaign website showing him wearing his State Fire Marshal Division uniform, badge, and gun. Specifically at issue in this motion are two photographs on Mr. Rodriguez's campaign website. One picture of him in his division uniform and badge, and a second picture of Mr. Rodriguez with his badge and gun in what appears to be a classroom setting. This commission has established a hard line regarding a public employee's use of the physical accoutrements of his office or position to bolster his endorsement of a person's candidacy, including his own candidacy. The reason for this hard line is that the use of the physical accoutrements of public office, including a uniform, gun, and badge, have been found by this commission to provide the impression that the public officer is acting in an official capacity and that the candidate is endorsed by the law enforcement agency, providing that candidate with an unwarranted advantage. Mr. Rodriguez admits that he posted the two pictures at issue to his campaign website for purposes of his election as a school district trustee. He also admits that these photographs show him wearing his State Fire Marshal uniform, badge, and gun, the accoutrements of his public office. We therefore request that the commission apply its previous precedent and grant the executive director's motion for summary judgment and find that Mr. Rodriguez committed 4 violations of the ethics law. The executive director's motion shows that summary judgment should be granted against Mr. Rodriguez as to violations of 2 provisions of the ethics law. NRS 281A.402 for his use of public position to secure unwarranted privileges and preferences for himself, and NRS 281A.400 subsection 7 for his use of government property and equipment to benefit his personal and pecuniary interests. Looking first at Mr. Rodriguez's violation of NRS 281A.400 subsection 7, this commission has previously determined that public employees may not use government property, which includes uniforms, guns, and badges, in support of any campaign in which they have a significant or personal pecuniary interest, including their own campaign. In fact, this commission has definitively concluded that no state or local government law enforcement official, including an elected incumbent official, may wear his uniform or badge or other physical accoutrement of the office in support or opposition of a political campaign, including his own. Such use constitutes a violation of NRS 281A.400 subsection 7. The undisputed facts in this matter prove that Mr. Rodriguez had a significant personal and pecuniary interest in his campaign for school district trustees. First, this commission has precedent that incumbent public officers have a significant personal and financial interest in maintaining their elected position. Mr. Rodriguez therefore had a significant personal and financial interest in his campaign to retain the trustee seat that he had previously been appointed to. Mr. Rodriguez also admits that he receives the salary for his trustee position. Under the ethics law, he therefore has a pecuniary interest in retaining his trustee position and salary that comes with that position. The evidence also shows that Mr. Rodriguez used government property in support of his efforts to be elected to the trustee position. Mr. Rodriguez admits that the 2 photographs at issue show him wearing his uniform, his badge, and his gun. He further admits that he posted the 2 pictures to his campaign website in support of his campaign for trustee. Mr. Rodriguez's use of the 2 photographs are therefore each a violation of NRS 281A.407. Looking next at his violation of NRS 281A.402, public employees have a responsibility under the ethics law to avoid conflicts between their private interests and the public they serve. That is the foundational mandate that we as the Ethics Commission have to enforce. Public employees must therefore not use government time, property, or resources, which this commission has found includes uniforms, guns, and badges, to benefit their own campaign. In a similar case, this commission found that a sheriff's endorsement advertisement that showed his badge and uniform resulted in an advantage. In finding that the use of the badge and uniform in that matter was a violation of NRS 281A.402, this commission has stated that it continues to caution against any attempt, even an incidental one, to bolster a political endorsement by the use of a public office and associated accoutrements of any government property, equipment, or resources. Such uses provide the impression that the public officer is acting in an official capacity, implicating NRS 281A.400 subsection 2. Again, stipulated fact that the 2 photographs at issue show Mr. Rodriguez wearing his uniform, his badge, and his gun, and that they were posted to his campaign website in support of his campaign. Under this commission's precedent, Mr. Rodriguez's use of each of the photographs at issue is therefore a separate violation of NRS 281A.402. As requested in our motion, the executive director also respectfully requests that the commission grant the motion limiting and find 4 total violations of the ethics law, 2 each of subsections 2 and 7. Based on the factors contained in NRS 281A.775, we further request that the commission determine that Mr. Rodriguez's violation of the ethics law that all 4 were willful violations. This commission is the basis for that request is that this commission has previously determined that violations of those subsections for use of accoutrements of office in a campaign are serious violations. Mr. Rodriguez continued to maintain the photographs at issue on his campaign website even after he received notice of this investigation, and they continue to be maintained on his website to this day. And additionally, Mr. Rodriguez realized a financial gain as a result of his violations through the salary he receives as trustee, and because the campaign website on which they were posted solicits and accepts monetary donations to his campaign. The executive director further requested the commission apply the following penalties in this matter: a reprimand from the commission, a requirement to attend and complete ethics training, and a civil penalty of $1,250 for each violation, for a total penalty of $5,000. you I'm available for any questions you might have.
Thank you. Mr. Hosmer Henner, please present any argument that you have on Mr. Rodriguez's response to the executive director's motion for summary judgment, and also go ahead and present your motion for summary judgment. If you could, thank you.
Thank you, Chair Dufferin. The issues are relatively similar, so there's not much of a distinction between our opposition to the motion for summary judgment and our counter motion.
Sir, could you speak up just a little bit?
It's not the first time I've heard that in a courtroom, so I'll try to be a little louder. The issue of the interaction between law enforcement and political campaigns has been an issue for this commission, not only this year, but in recent years. But this commission has never taken the position that the conduct that Trustee Rodriguez engaged in was barred by Nevada's ethics rules. There's never been an opinion that the use of prior historical photographs of someone's prior public service represents a violation of Nevada's ethics laws. That's a new decision. And our position today is that there are critical distinctions between wearing your uniform and a badge, your gun, and appearing in a debate, appearing in a television advertisement. And that's fundamentally different from what is at issue today, which is showing accurate historical photographs taken prior to any involvement in the political arena as part of your campaign biography. We think that this case is about an issue that is clearly one that the commission's decided, but one that shouldn't be painted with a broad brush. Because when you use that broad brush, you don't define the lines between prohibited and appropriate conduct. You blur those lines so that individuals and candidates, and specifically law enforcement individuals, don't have the ability to know what is and what is not appropriate conduct. If the commission were to decide today, for the very first time, that you cannot use in your panoply, in your kind of panorama of your life, one specific picture of one specific job, then that doesn't help voters. It doesn't reduce the appearance of impropriety. It actually obscures the truth. Imagine if there was a photograph taken from every year of Trustee Rodriguez's life, showing every one of his jobs. He can show himself being a firefighter. He can show himself being in the military, but he can't show himself in uniform doing the work that he did and that was reported by the media. There's not a single precedent from any jurisdiction that the staff of the commission has shown to penalize this type of conduct. We think there's a difference between scenario one, where a law enforcement officer is running for office and they wear their uniform and badge in a commercial endorsing someone else or endorsing themselves or supporting their own campaign. And scenario two, this one, where someone is showing accurate historical photographs from their life. That doesn't use government resources, because the individual is not taking their uniform and badge to a political event. They're not wearing it in a political advertisement. They're using a photograph that someone else took that doesn't include governmental resources. Briefly, Trustee Rodriguez has a long and distinguished career in public service, and that we'll try to rely mostly on what's on our motion papers. He served in the National Guard. He toured in Afghanistan. He worked for the Nevada Department of Public Safety and the State Fire Marshal Division. He's been a den leader for the Boy Scouts and active throughout our community for years. The two photographs in question were taken prior to his involvement with the Washoe County School Board. As counsel for the commission, associate counsel mentioned, he was appointed in July 2020 to the Washoe County School Board and then ran for re-election in March 2022, ultimately being elected in November 2022. The very first time that Trustee Rodriguez was aware that these pictures, two of many on his campaign website, were potentially at issue, were when this commission issued a notice related to the complaint and then followed up with a panel determination that this was specifically the conduct in question that was potentially in violation of Nevada laws. And that determination wasn't made until November 17th, 2022, after the election had already concluded and the campaign website was essentially a non-issue. There are two violations here remaining. And the first is subsection 2 of NRS 281A.400. And that's a public officer or employee shall not use the public officer or employee's position to secure or grant unwarranted privileges. What's relevant here is that Trustee Rodriguez is the only individual who couldn't use this photograph. He didn't request this photograph to be taken, these photographs to be taken. He didn't use any resources to take them. They were part of his routine duties, and other people took them and then distributed them publicly. That means that under Nevada's ethics laws, his opponent could use them in his campaign. Other people could use them, the news media could use them, but the only individual who couldn't use these accurate historical photographs would be Trustee Rodriguez. We don't think that Nevada's ethics laws should be interpreted to actually make the only individual who can't use these photographs to be the one who didn't actually benefit from them, be involved in their creation or have anything to do with their creation, but yet everyone else can use them. And the second violation is under subsection 7 of NRS 281A.400. And that's a public officer or employee shall not use governmental time, property, or equipment to benefit themselves personally. There is a distinction between using governmental property, a badge and uniform, and using a photograph of Trustee Rodriguez in uniform. There is no use of governmental property to secure an unwarranted position when Trustee Rodriguez uses a photograph similar to those that appeared in the Reno Gazette Journal on his campaign website. The photograph cannot be government property. It wasn't taken by any sort of government resource. It wasn't taken as part of a campaign or to benefit a campaign. So we can't blur the lines between the badge and gun, where you show up to your campaign office, pose for a photograph in a uniform and a badge, to take a photograph for using on your billboards. And this situation where you use a photograph that existed regardless of whether Trustee Rodriguez ever ran for office in the future, or was appointed to the office, ever ran for any political point at all. And that photograph is not governmental property. So whether he put it on his campaign website or not, it still existed. There was no use of government property to create that photograph. And that's the critical distinction we have here. We think there really is no doubt that this would be a new and dramatically different holding than the previous decisions. If you look at what this commission has ruled on in the past, in the Kirkland situation, there was a sheriff who appeared in a television advertisement in full uniform endorsing a judge. In Kuzanik, it was a sheriff or a candidate who appeared in full uniform with a badge in his political advertisements. And there actually was he took a specific photograph of his badge, put it on his website underneath the word contribute. These are all very different situations than someone using public photographs taken not for the purpose of this campaign to show his biography, even as part of a campaign website. And then in the last situation with Antonoro, Sheriff Antonoro, this was an individual who wore his uniform during 3 debates and on a campaign float and appeared in pictures specifically for the purpose of the campaign. We think the timing really matters here between someone who shows up at their campaign office, appears at rallies being photographed in their uniform and badge, and someone who shows accurately who they are in the past. These photographs, again, would have existed regardless of whether he ever ran for office. So there's no specific usage of any government resources. And to show how we believe extreme this ruling and criticism of Trustee Rodriguez would actually be, there's not a single other jurisdiction that the Associate Council has pointed to where this conduct has been prescribed. Not one. 51, if you want to include Guam and Washington, D.C., not one authority from any state, from any other jurisdiction, specifically not at the federal level, where we already know the Hatch Act takes a different position, but not one authority where this specific conduct has been prescribed. Now, their response to our motion was Nevada can interpret its own rules. Nevada can make its own position. Absolutely true, but why? What reason is there? Because there's not a difference in the statutes. There's not a difference in the precedent. What reason would Nevada have to stand alone and respond in comparison to every other jurisdiction, including the federal government, to say that an individual cannot accurately depict themselves using prior historical photographs when they weren't doing anything using their current position to secure those photographs? We've provided examples from Massachusetts, North Dakota, and other jurisdictions in our motion practice that show every other jurisdiction that we found has taken a different position where you can use a photograph. A judge could use a photograph in a campaign in North Dakota of them in a robe, as so long as they weren't posing in that robe for the purpose of that campaign photograph. In Massachusetts, a candidate could use a photograph of them in their office with the county seal and all the other accoutrements of office that was taken by a news media organization, so long as they weren't staging that photograph to use those public resources for the benefit of the campaign. But if those photographs existed independently, even if they were taken during the campaign, and these photographs were not, but even if they were taken during the campaign, you could still use those photographs. We think there are really two key facts that are undisputed that require summary judgment to be granted in favor of Trustee Rodriguez. The first is that these photographs were taken prior to his appointment, prior to his campaign. Because of that, you cannot argue that there is the use of the photographs, the creation of those photographs were used to secure an unwarranted position, or where the photographs were created based on the use of his public position that no one else could have created. And the second were that the photographs are not themselves government resources. One of the photographs was on the phone of one of the parents in the classroom or the teacher in the classroom. And this was taken, I believe, in early 2020. That's not a government resource. The photograph taken at that point in time wasn't a government resource. So because those two facts are undisputed, we're happy to go through any of your questions. We don't believe this commission should break new ground, create a new precedent that is different from every other jurisdiction, and that's not supported in Nevada. Thank you very much.
Thank you. Ms. Bass, would you like to reply?
Yes, thank you. For the record, this is Elizabeth Bassett, Associate Counsel. I'd like to kind of take a few of these things in turn. Starting with one of the last things that Mr. Hosmer-Henner talked about, he repeatedly mentioned that there are no, there were no citations provided in the executive director's motion by myself that support that any other state has ever taken this position. That's important language to pay attention to because there was no attempt to cite to other jurisdictions as to whether they take this position or not. Nevada's law is clear that we do not allow, the ethics law does not allow the use of these accoutrements of office. And our ethics rules are different from state to state. So it was not relevant to the motion whether other states take this position or not. Mr. Hosmer-Henner's representation that we would be out of line with other states isn't actually supported. He's just mentioning that I didn't mention any cases in other jurisdictions that would be the same as this decision. That does not mean there are none. A case in point is that all of the decisions that are cited in Mr. Rodriguez's motion and opposition have nothing to do with police officers. They're judges. We also allow judges in this state to wear their robe. They're the feel of a county. They're not similar. They're not the same. There's nothing about this, nothing cited by Mr. Hosmer-Henner or Mr. Rodriguez that would support the statement that a decision in favor of the executive director's motion for summary judgment would be out of line with the rest of the states or the rest of the country. This commission has been very clear in its opinions regarding the use of the accoutrements of office. It's settled rules, settled laws. Whether Mr. Rodriguez availed himself of that knowledge is his responsibility. Whether he knew that he was violating the ethics law when he put them on his website isn't relevant to whether it's an ethics violation. Likewise, who took the photo is irrelevant. This commission has found violations where the photo was taken by a third party, not by or at the behest of the subject. We've had recent opinions and recent agreements on that, including Chief Soto here in Reno. And so he may not have been involved in the creation, but he used them in support of his campaign. That's the vital issue here, not whether he took the photo, not whether he requested the photo. He then took the photo and he put it on his website under his About Me and where he's touting why he should be the trustee. So the creation of them is not what's at issue. The physical photo itself is also not at issue. Mr. Hosmer-Henner repeatedly said that the photos were not the property of the government, were not government resources. There's never been any allegation that there is, and that has no part of the commission's precedent. what he is wearing that is the property of the government. It is his badge, it is his gun, it is his uniform. And it is those things that are pictured, not the physical digital file or the picture you can touch that are the government resource. It's that he is using the government resource from his job in law enforcement to promote his own candidacy. And the law of this commission is very clear. You cannot do that, whether it's for your campaign or someone else's campaign. It's not the physical picture, it's not who took the picture, is what is represented in the picture. And it's clear and undisputed what's represented in the picture is Mr. Rodriguez wearing the accoutrement of his office for the State Fire Marshal Division, which is not allowed. This requested loophole about the use of historical photographs and that they should be allowed to support campaigns, if allowed, would gut the commission's rules regarding this issue. Basically, this would mean that any public officer or employee planning to run for office could simply take photographs before they announce their campaign. They could find old photographs that depict the same thing that would be depicted in the current photograph. And then those photographs would arguably be historical, and then they would not fall within the ethics rule. This is clearly a loophole that should not be allowed. Nothing about these alleged historical photographs of Mr. Rodriguez is any different than a current photograph of him in his uniform with his badge, with his gun would be. And those current photographs would be an ethics law violation. The ethics law is concerned with the impact of the photographs on the viewers. The photographs like those at issue in this matter provide the public with the impression that the public officer is acting in an official capacity. That is what this commission has ruled in the past. And it also provides the impression that the law enforcement agency represented through the accoutrements office is endorsing the candidate. The impact of alleged historical photographs of candidates and the improper impression that they give the viewer are no different than a current photograph would be. It's the same impression that is given to the viewer of the photographs. There has always been a different rule for accoutrements of office for a law enforcement officer. Mr. Hosmer-Henner points out, oh, you're separating them out, you're making it a different rule. That is the rule. It is already a different rule. The precedent is clear. You cannot use these accoutrements. It doesn't matter if it's in an old picture. There's nothing on the website that says this is an old picture. There's nothing on the website that says he didn't take it. The issue we're concerned with is not those details, but detail of what the photograph portrays and the impact it has on the viewers of the campaign website when they see them. I think that is all I have.
Thank you. I'm going to give you an opportunity, Mr. Hosmer-Henner, just to, if you would like.
Yeah, thank you, Chair Duffin. Can I, I'm not sure how the exhibit books work here, but can I direct your attention to ED 0024? It's in tab 6.
It's exhibit 4.
Is it included in the motion for summary judgment as an attachment or just in the exhibit book?
Oh, ED.
Maybe while we're trying to find that, you can describe what it is that we can look at.
But this is the collage of the photographs. And the argument was there's no difference between an old historical photograph and a current photograph, and the impact on the viewer is the same. With a healthy dose of skepticism, I would respectfully say that there is a difference. And then if you see these photographs, there's not an indication that there's any support from a public agency, that there's any indication or lending of those credentials in the same way that someone standing up in a television commercial in a badge and uniform saying, I endorse this other candidate, would provide that same impact on the viewer. And part of the reason for that is because this isn't a loophole. This is a fundamental difference between the use of government resources, and the statute is designed to talk about the use and whether an individual and a public officer is using their position to do something that someone else couldn't obtain. Anyone can use these photographs. The reason those other opinions came out the way they did was because the only person who could pose for that photograph was the public officer who had the badge. When someone goes to a debate, when a sheriff goes to a debate, They can go to a debate in uniform and badge, but no private citizen. That's because they're the only ones with access to the government property. When they appear in a television commercial, they're the only ones with access to that uniform and badge. This photograph wasn't created because Trustee Rodriguez had access to a badge and a gun at that time in order to support his campaign. It was created because he happened to be a public officer at the time, and he was wearing that uniform as part of his routine duties. That is a fundamental distinction. And that is why the statutes are written how they are, because it's not just about appearing in a uniform. It's about the fact that someone has access to that uniform that a private citizen doesn't. His opponent could have used these pictures. Anyone in the media could have used these pictures to describe the campaign. And Trustee Rodriguez equally should be allowed to use accurate historical pictures, which aren't a loophole, but are the thing that are the most accurate depiction of his prior life and his prior public service. And one of the statements that Associate Counsel said was, we allow judges to use their robes in these prior advertisements. You know, the hostility, there should be no specific hostility towards law enforcement officers that make them uniquely put in a position of not being able to depict what they did in the past. And I understand that there is the opinions of this commission that have held that you can't actively use those uniforms to convey the impression that you're supporting your own campaign or someone else's campaign, but that's not what this case is. This case is about someone going through their biography and depicting every stage of their life. So if a teacher can stand outside of a school and run for office using those public resources, if a judge can use a robe and say, I used to be a judge and this is what I did and these are my credentials as a legislator, can have a picture of them taken in their offices, then why can't a law enforcement officer use a prior photo of themselves doing their work, not standing at a campaign event, but simply doing what they were hired to do at the time, and a picture that existed not at their own request, not at their own staging, but simply a picture that existed as part of their accurate life? There would be a gap. This wouldn't be something that would mislead voters or convey to them that there is a difference between their opponent and Trustee Rodriguez with respect to the endorsement of this agency. It would actually be misleading to voters to have black spaces, squares with just during this time period, Trustee Rodriguez served in the State Fire Marshal Division, but every other aspect of his life was represented. So there is a distinction. And specifically, I want to talk about the timing here, because who took the photo and when it was taken is critical. It's not an ancillary issue. And if this commission adopts a rule, we don't believe it has done before, that no photographs can ever be taken or ever be used of someone doing prior work in law enforcement. So not even, that would mean that not only Trustee Rodriguez couldn't use this private photograph taken by a parent, he couldn't even use a newspaper article that was taken by a reporter on part of his campaign website. That's a new decision. And the reason it matters that other jurisdictions haven't reached that result is because it's so overbroad that it could potentially chill the First Amendment right to his expression and depiction of his own prior life. There's very little doubt on a case-by-case basis that Trustee Rodriguez, the choice of these pictures are not actually going to lend create the appearance of impropriety or create the appearance of an endorsement, no more than the pictures of him serving in the National Guard. So to create an artificial distinction between those two categories of historical photos seems to me unsupportable according to our statutes, specifically because of the linkage between the word use and why we care about the use of that government property. If they are not actively using the government resources that only they have access to, then we submit there's no ethical violation and request summary judgment in favor of Trustee Rodriguez on both claims. Thank you.
Thank you. Okay, I think at this point, I'm ready to open up questions from any commissioners that have questions.
Mr. Vice Chair,
Commissioner Oscarson.
thank you very much. Counselor, I appreciate your point and your very detailed argument. I have one concern. And you referenced a hostility towards law enforcement. I hope that was not directed at the commission itself, but perhaps at the law that exists, because that is absolutely not descriptive of what this commission does. And I want you to clarify for me on the record, please.
Oh, of course. The idea was that there is a specific separate rule under the Nevada statutes for respect, with respect to the law enforcement and the use of the uniform or badge. Certainly, the commission only interprets those rules as drafted by the statute. So certainly clarify that there was no hostility. My interpretation is that there's no hostility towards law enforcement from the commission. So I hope that clarifies it. And my point was simply that there should not be a rule that creates that artificial distinction between members of law enforcement and other.
Appreciate your point. Appreciate you doing that. Thank you, sir.
I would also like to clarify that the rule does not only apply to law enforcement. The rule relates to any uniform or physical accoutrement of office. So that does not only apply to law enforcement. And as Mr. Husmer pointed out himself, a teacher staying outside of school, they could have a picture, they could not inside, they could not using any accoutrement of their office either. This is not limited to law enforcement, nor is the commission enforce those rules in that way. It is the use of government property that then conveys to the viewer of the photograph or the endorsement that government entity is somehow supporting the candidacy of the public officer. That's the issue. Not just that it's law enforcement, but that it's any similar type of government agency.
Thank you. Any other commissioners have any questions? Commissioner Lowry.
Thank you. Council Hosmer Hinner, thank you very much for your presentation. I have a few questions. When you reference your clients as these photographs being of his prior life and prior public service, I want to make sure I have my facts correct. He was in fact working as a state fire marshal in the Nevada Department of Public Safety at the time that he was running for office, correct?
Correct.
Okay. And what would be the indicators to the public who viewed that website that these pictures of him in his uniform and badge and gun with the accoutrements of his office, what would be the indicators or evidence to the public that these photographs are historical?
Trustee Rodriguez, I don't know if you heard his comment, but his current weight would be his facetious response. But there in some jurisdictions and at the federal level, a disclaimer is suggested. And so there was not a disclaimer on the website that all of these photographs were taken prior to his campaign. With respect to the timing issue, when I talked about his prior service, that was because that was what he was doing at the time the photographs were taken, not that he stopped that service once he started campaigning.
Okay. And this concept of historical, fair to say that we're using it or you're using it as a term of art, an exception, a mitigator, a qualifier. Where in Nevada's case law or the NRS is the term historical utilized in the way that you're using it in this case?
It's in the language of NRS 281A.400 subsection 2 and 7 that use a specific verb tense when they talk about what actually is prescribed by these statutes. And so, for example, subsection 2 says a public officer or employee shall not use the public officer's or employee's position in government to secure or grant unwarranted privileges, preferences, exemptions, or advantages for the public officer or employee. Our interpretation and what we submit that statute stands for is that you cannot contemporaneously use your public position to benefit you personally, but that when there's a significant gap in time, that the taking of this photograph, because he wasn't running for office at that time, that it's fundamentally different from someone who appears in an advertisement wearing their uniform and badge contemporaneously, and that without that temporal linkage, the statute does not prescribe the conduct at issue here.
So how much time would pass your analysis to make a photograph historical?
For the purposes of this analysis, a photograph taken prior to the campaign for office would be historical. And the reason is that photograph wasn't taken to secure or grant unwarranted privileges. Now, we recognize that what Associate Counsel on the other side has said is that there could be a loophole where you start staging photographs and preparing for your campaign. And so you do that one day before you announce office, and so that you're grandfathered in. That's not the situation here. Perhaps that will come up in a separate situation where someone is transparently using their accoutrements of office in order to support themselves or benefit them personally. But there's no evidence of that here. It can exist, as Trustee Rodriguez was not even remotely considering being involved with the Washoe County School Board at this time. So that's a line drawing exercise for another case, but there's absolutely nothing here that would connect these photographs and the time they were taken and the use of those resources at the time they were taken to any benefits for Trustee Rodriguez in the future.
Thank you, counsel.
I heard Associate Counsel Bassett has a comment.
I wanted to address first the question of where historical is contained in the NRS. It's not. What subsection 2 and 7 both say is that a public officer shall not use their position in government to secure these privileges. That's subsection 2. Subsection 7 likewise says that they shall not use government time, property, or equipment or facility to benefit themselves. Neither of these refer to historical, and the fact of the matter in this matter is these photos are representations of Trustee Rodriguez's current employment. And that's why this is at issue. There's nothing historical. It's saying the statute precludes him from using his current position, and that is exactly what is at issue here. He's using his current position, the accoutrements of that office, in support of his campaign. Second, I'd like to address this issue that this case is different from another case. That exactly highlights why this loophole is unworkable. It would require there to be all sorts of levels of trying to review, was it taken a day before? Was it taken 5 days before? Was it taken a year before? Were they contemplating a campaign at that time? That becomes an unworkable standard frankly, for any public officer to determine where the line is for themselves and for them to try to prevent themselves from having an ethics law violation. And it becomes unworkable for the commission. We have to take a look at this case in its context to other cases, not wait for another case to come along that might have different facts. The fact is the law is clear that you cannot use the accoutrements of office, whether the picture was taken a day before a campaign was started or the day of.
Thank you. Commissioner Grunwald, did you have some questions?
Well, I have a point that I need to ask our counsel. May I ask questions of Mr. Rodriguez directly? My understanding is for motions for summary judgment, we only rely on what the attorneys are saying.
That's correct, yes. So we would go to an adjudicatory hearing, at which point you'd be able to question counsel or the parties.
Okay. Then I don't have any questions, but I do have an argument about why I do not think that we should grant summary judgment to either party. And we should have an adjudicatory hearing. Do you want me to present that at this time?
Are there any other questions?
Yeah, before we get to that argument, I had a couple questions that I wanted to ask counsel for Mr. Rodriguez. So this notion of historical photographs, whether or not those photographs are listed as, even if they were listed as historical on Mr. Rodriguez's website, does that change the impression that those photographs give of him in his capacity as a candidate? In other words, if they're current photos or old photos, and I think you mixed both of those on the website from what I saw. And we were only talking about the 2 photographs, which was his current position at the time, which is working for the state fire marshal, which showed his accoutrements of his office. But there were other photos as well. But none of the photos that I could tell had any kind of dates on them. They were so a casual reader that just looked at the website, started looking at these photos, would not know if they were historical or not. So I guess my question is, does it really matter?
Yes, in brief, because we're looking at the statutes that talk about using. And so what I was a little surprised to hear Associate Counsel say is it's a representation of his current office. Now, that would mean that if Trustee Rodriguez switched to a different position, somehow his conduct would be immunized because he was no longer showing his current position, even though the photographs were taken prior to the campaign. I think that's a difficult standard to apply when someone is switching jobs in public service, that all of a sudden they could, what I heard Associate Counsel say is that they actually could use indicia of their office, so long as that wasn't their current office. And I think that's a standard, again, that's difficult to apply and interpret here. But with respect to your specific question, why does it matter if there's not a specific date here? And with respect to whether a individual sees the photograph and realizes whether the photograph was taken prior to the campaign or not, in an ideal world, the statutes would be written perhaps to have require a disclaimer. And I think that's similar to what's taken at the federal level for the hatch. Not that the use of the photographs is completely barred, which we think would be inaccurate and misleading to voters, but that the photographs are required to have a disclaimer that the photograph doesn't imply the support of the Nevada State Fire Marshal Division. That probably is a workable solution at some point in the future. But with respect to these statutes, it doesn't just to say a public officer shall not do anything to imply the support or to mislead voters or to say anything that could be a misrepresentation. They specifically say they shall not use their public office. They shall not use public resources. And without that linkage, as Associate Counsel conceded, the photographs are not government property. So at the time that the photograph was taken, was Trustee Rodriguez using his office, using his government resources to secure an unwarranted privilege? And that's absolutely not the case. So those claims have to be dismissed in this case. And that's the reason that whether there's some similar effect on voters isn't really the issue. It's whether he did anything wrong with respect to those government resources that only he had access to. And we would submit that based on this commission's prior precedent, that could be the case if someone actively uses their current uniform to go film a TV advertisement. But that's because they're using those government resources in their office to get something. When Trustee Rodriguez appeared in that classroom, talking to those kids, he wasn't using his government badge or resources to get anything. There was nothing to get. And a year later, when he ran for office, that didn't become a violation simply because he ultimately ran for office and showed a photograph where he was prior to that wearing his uniform and badge.
Thank you for that.
Can I address that?
Please. Briefly.
Very briefly. The point Mr. Hosmer-Henry is making is that at the time the photo was taken, he was not using that as part of his campaign. When he was using it was when he posted the photos to his campaign website. There is no ethics law violation for someone taking a picture of you in your uniform a year ago. That's certainly not an ethics law violation. The question is when Mr. Rodriguez used that photo, put it on his campaign website, asked people to vote for him, solicited donations to his campaign, that is when it became an ethics law violation. So talking about what was happening at the time the photo was taken is not the timing issue we're looking at. The timing issue is when was this put on Mr. Rodriguez's campaign website? He clearly put it on there for a reason. The reason was to bolster his candidacy. That is the ethics law violation. That's what's not allowed. Also, nothing in my argument is meant to, I'm dealing with the facts in front of us in this case, as I argue today. I don't mean to imply someone else would be immunized in another situation. I'm addressing what we are here today, and what we are here today looking at is Mr. Rodriguez's use of his current public office to support his private candidacy and pecuniary interests.
Thank you. Before we get to Commissioner Grunwald's argument, any other questions? Any other commissioners? Seeing none, Commissioner Grunwald.
this is a procedural thing. I'm uncomfortable with granting either motion for summary judgment, and I would prefer to go to an adjudicatory hearing. Because I want to hear the testimony of any other witnesses that they might present to assess the credibility or confirm facts. Specifically, I have some questions for Mr. Rodriguez. I think that just going on a motion for summary judgment, in my experience, it's been a reversible error, meaning if somebody wanted to appeal, they might be able to find it some loophole to appeal. So I don't like the idea of a motion for summary judgment, and since we're all here and the time is set to have an adjudicatory hearing, I would prefer to do that rather than grant either motion for summary judgment.
So is that are you making a motion or are you just making an argument?
I'm making an argument. I want to see if there's anybody else who has the same feeling, or if someone wants to make a motion either grant either party's motion.
Thank you. Commissioner Lowry, Commissioner Oscarson, do you have any opinion on that? Have any feeling one way or the other? Or are you ready to make a motion?
Commissioner Lowry,
please.
thank you. My motion would be to grant the summary judgment for the executive director.
Yeah, I'm not quite ready for a motion yet, but
Yeah, I'm just letting you know where I stand.
thank you. Okay, well, that is not a motion. I know where you stand. We all know where you stand. Commissioner Oscarson, did you have any concerns or questions regarding either comments by either of the other two commissioners?
This is very interesting. I'm kind of I'm kind of thinking to go with Commissioner Grunwald and hear some additional information and see what becomes of it, rather than make a decision here. I think that I think I could go either way, and I think I need a little bit more information and hearing from the trustee and hearing what his thoughts were. You know, having run campaigns and done those kind of things in the past, I understand how some of those things can come out and be done. And I'd like to hear more from him. I believe, not to belabor the point any, but I think that there's some validity in hearing him speak to us directly and what his thought process was during that period of time. He's obviously got a significant career in public service, and I think we owe it to him to hear what he has to say if he's willing to do that.
Thank you, Commissioner Oscarson. My thoughts are all over the place. After hearing both parties and reading all the materials, my original inclination was to grant summary judgment to the executive director, but having some of these other issues come out and not being able to question Mr. Rodriguez, I tend to agree with Mr. Oscarson and Commissioner Grunwald. So I would make a motion that we do not grant either one of these summary judgments, and that we go ahead and have an adjudicatory hearing on these issues. And so formally, I would deny both motions. The commission has reviewed the entire record for this matter and has considered the pending motions and arguments of counsel, and I move to deny both motions for summary judgment because there are issues of fact and dispute, and it would be beneficial. It would benefit the commission to hear the testimony of witnesses and to review all evidence to make its decision. Further, I direct counsel for the commission to prepare an order in coordination with myself, the vice chair, to reflect the determination of this commission. That's my motion.
Commissioner Grunwald, I second that motion.
All those in favor say aye.
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 Those opposed?
Opposed.
So it carries 3-1, so motion carries. So that's what we're gonna do now is take take another small break, 5-minute break, and we will prepare for our item number 6, which is the adjudicatory hearing for Mr. Rodriguez. And let's take a 10-minute break.
Oh, Commissioner Yan.
Commissioner Yan.
Yes, thank you. I already made my disclosure and abstention prior to the summary judgment. Would you guys like me to do the same thing for the adjudicatory hearing, or can I just bow off for a little bit? I'm happy to do either one.
We're gonna need you to do that because it's a separate item.
Okay, sounds good.
All right. Thank you. Let's take a 10-minute break.
We have to.
Okay, we are back on with item number 6. For the record, it's 12:07, Wednesday, March 15th, 2023. This is item 6 pursuant to NRS 281A.745. This is an adjudicatory hearing. We hear testimony, receive evidence, deliberate, and render an opinion concerning ethics complaint case number 22-051C regarding the conduct of Joseph Rodriguez, trustee, Washoe County School District, Lieutenant, State Fire Marshal Division, State of Nevada, including determination of whether there are violations of the ethics law and possible issuance of fines or penalties pursuant to NRS 281A.775 and NRS 281A.785. I believe we have, I need to state the panel members that are not participating.
Yes, and I would have Commissioner Yen make her disclosure now.
Okay, go ahead. Any disclosures by any commissioners?
Yes, thank you, Vice Chair Dufferin. Commissioner Yen, for the record, in compliance with NRS 281A.420 and judicial canons applicable to me as a quasi judicial officer, I'm disclosing that I'm a partner with the law firm of McDonald Carano, of which Mr. Rodriguez is a client. Therefore, pursuant to NRS 281A.065 subsections 4 and 5, I have a commitment in a private capacity to my law firm and the client based on my law firm's continuing business relationship with that client. Consequently, the independence of judgment of a reasonable person in my situation could be materially affected by the conflict in participating and voting in this matter. To avoid conflicts of interest and any appearance of impropriety, I am disclosing the conflict and will be abstaining from any participation on this matter. I've also consulted with Deputy Attorney General St. Jules, who agrees with my disclosure and abstention in this matter. Thank you.
Thank you, Commissioner Yan. Any other disclosures? Hearing none. Proper notice has been provided and waivers have been received for ethics case number 22-051C. Further, the members of the review panel, Chair Wallen and Commissioners Towler and Sheets may not participate in the consideration of the adjudicatory hearing pursuant to NRS 281A.220 subsection 4. Commissioner Yan has just abstained and also may not participate. All of the other commissioners may participate and vote on this matter. So let's do appearances, please. Would the attorneys please identify themselves, their clients, and any witnesses which are present to be sworn in for the record?
Good morning. For the record, I'm Elizabeth Bassett, the Associate Counsel for the Commission on Ethics. I'm representing the Executive Director, Ross Armstrong, who is here today. The only witness that we will be calling is Mr. Rodriguez himself.
Adam Hosmer-Henner of McDonald Carano on behalf of Trustee Rodriguez, and the only witness we anticipate calling will be Trustee Rodriguez.
Thank you. Just a preliminary matter. So we do know that all exhibits required for this hearing, including any books, papers under subpoena, have been submitted to the commission. So we have all the materials. As the presiding officer, I've issued certain rulings relating to evidence. Mr. Rodriguez submitted an adjudicatory motion, which I denied yesterday by oral and written order. The executive director submitted a motion in limine, which I granted yesterday by oral and written order. The evidence books have been provided to the commission, and the parties will now stipulate on the record as to certain facts and the admissibility of certain documentary evidence. Counsel, please put the party's stipulation on the record.
And that, so the parties have stipulated to the first 7 of the executive director's undisputed facts. So I'll go ahead and read those into the record. Mr. Rodriguez was appointed to serve as a Washoe County School District trustee beginning in July 2021. Number 2 is that Rodriguez has been employed by the State Fire Marshal Division of the Nevada Department of Public Safety since at least 2021. Stipulated fact 3 is that the State Fire Marshal Division is a law enforcement agency. Stipulation number 4 is that Rodriguez successfully campaigned to be elected as a Washoe County School District trustee in 2022. Stipulated fact number 5 is that Rodriguez maintained a campaign website at joe4washoe.com for his election as a Washoe County School District trustee in 2022, known as the campaign website. Stipulated fact number 6 is that from May 2nd, 2022 to the present, the campaign website contained a picture of Rodriguez dressed in his state fire marshal uniform and badge. And stipulation number 7 is that from May 2nd, 2022 to the present, the campaign website contained a picture of Rodriguez wearing his state fire marshal badge and gun in what appears to be a school classroom. The parties also stipulated to the admission of certain of the exhibits contained in the joint exhibit book. And those exhibits are numbers 1, 2. I'm sorry, 2. I didn't mean to say 1. 2, 3, 4, 5, 6. Oh, 5, not 6, 7, and 8. So 2, 3, 4, 5, 7, and 8.
Mr. Osborne, is that your understanding?
With respect to 2, 3, 4, 5, 7, and 8, yes.
Okay. And the stipulated facts, you're in agreement with those?
We are.
Thank you. What I'd like to do at this point is swear in, have the court reporter swear in Mr. Rodriguez, please.
I could get you to raise your right hand, please. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. So I'm going to limit opening statements to 15 minutes for each side, since we've on our previous item, we've heard a lot of this information already, and so I want to make sure we have due process on both sides, but I also want to eliminate any unnecessary verbiage to this. So let's do, each party may provide up to a 15-minute opening statement. Ms. Bassett, you will begin, please.
Thank you for the record,
Chair
Elizabeth Bassett.
Duffin, if I may, I'm happy, since we just went over most of these arguments, unless it's required, I'm happy to waive opening statements and move it to the closing statements, since we've already addressed these issues.
Well, can I address that? My concern is that we do have to make a record. If this is
Yeah.
appealed, I need to have my arguments in the record, that this record is separate from the one on the summary judgment motions, because those were denied.
Yeah,
all
let
of
me
them, so-
interject. Let me help you out here. I want to, because this is a separate item, and it's item number 6 as opposed to the last item we heard, we do need to have a complete record. So I do need just an opening statement from you on each side. But you can be as brief as you like, as we, if necessary, if anybody needed additional information that and they're hearing me now someday, they can go to item 5.
I'm also happy, in case it works, to stipulate to incorporate the statements that were made in item 5 into the opening of item 6.
What? Yeah, okay, then we were fine with that.
Is that okay?
That's good.
All
I
right.
would like to make a short opening statement since I've started with Chris.
Yeah, let's do that. Go ahead, please. We'll go ahead and agree to that. As far as I can tell, that's fine. If any commissioners have any concerns with that? Hearing none, we'll go ahead, Ms. Bassett.
Thank you. Again, for the record, good morning. I'm Elizabeth Bassett, Associate Counsel for the Commission on Ethics, representing the Executive Director. As you know, this matter concerns subject Mr. Joseph Rodriguez, who is a lieutenant of the Nevada State Marshal Division and is a trustee of the Washoe County School District. We'll be showing today by a preponderance of the evidence that Mr. Rodriguez violated both NRS 281A 402 and 407 when he posted 2 photographs to his campaign website in support of his election that showed him wearing his fire marshal uniform, badge, and gun. The preponderance of the evidence standard requires that the executive director show by the greater weight of evidence that Mr. Rodriguez violated the ethics law. What this means is that we are required to prove that something is more likely than not. In other words, in light of the evidence, do you believe that each element of the alleged violation is more likely true than not? You've already heard the stipulations that we've read into the record, and we've also admitted a number of exhibits. It is executive director's position that based on those stipulated facts, it's the evidence already shows a violation of NRS 281A 402 and 281A 407 by Mr. Rodriguez. Any further testimony would only go to whether his violation was willful or non-willful. Mr. Rodriguez's intent is not required for a violation of the ethics law. Therefore, what he was thinking or why he did something has no relevance to whether he violated the law or not. We've already read into the record sufficient evidence in the stipulated facts that both parties have agreed are stipulated to support a finding of a violation of both code sections. But I'll limit my argument to that for now.
Thank you. Mr. Osmer, go ahead, please.
Good afternoon, Chair, veteran and members of the commission. Adam Hosmer-Henner of McDonald Corona on behalf of Trustee Rodriguez. I'll incorporate all the prior arguments I made with respect to the summary judgment motion in the prior item into my opening statement. And I would just refer the commission to the 2 facts that we intend to prove today, which was 1, that the photographs were taken prior to Mr. Trustee Rodriguez's appointment or campaign for political office at the Washoe County School Board, and 2, that the photographs themselves are not government resources and that there was no use of government resources when they were posted to Trustee Rodriguez's campaign website. Thank you very much.
All right, Associate Counsel, please start the executive director's case by calling your first witness. And for each witness called, Mr. Hosmer-Henner will be provided the opportunity for cross-examination. And Associate Counsel may redirect at any time. A commissioner may ask questions. And you don't have, just let me know and we'll get all the questions in. Thank you.
First witness I call is Mr. Joseph Rodriguez. Could you, he's already been sworn.
He's sworn.
So can you please state and spell your name for the record?
My name is Joseph Rodriguez. That's first name is JOSEPH Rodriguez, RODRIGUEZ. And feel free to call me Joe.
Where are you currently employed, Mr. Rodriguez?
Well, I'm currently employed with the Washoe County School District as a trustee. And my other full-time job is I'm a lieutenant with the State Fire Marshal Division, where I serve as your Assistant State Fire Marshal.
In your position as a State Fire Marshal, do you work for the state of Nevada?
Yes, ma'am.
In your position as a Washoe County School District trustee, do you receive a salary?
If you can call it that.
You do receive financial
$9,000 a year. Yeah.
To support your reelection campaign, did you, well, first let's establish, how did you first become a trustee?
How did I first become a trustee? So I went through the appointment process in 2021.
So you were appointed to that seat.
I was appointed, yes, ma'am.
And then you subsequently ran for reelection to that seat.
Yes, ma'am.
To support your reelection campaign, did you create and maintain a campaign website?
Yes, with the help of my campaign team, yes.
And the address is the address of that campaign website what we've previously stipulated to joe4washoe.com.
Yes, ma'am.
Approximately when was your campaign website first created?
I believe around like springtime.
Spring of 2022?
Yes, ma'am.
Does your campaign website accept financial donations in support of your campaign for trustee?
Through a third-party account, yes.
But it does allow a viewer of that website to make a donation to your campaign.
Yes, ma'am.
Are you aware that a complaint was filed with the Nevada Commission on Ethics alleging an ethics violation against you?
Yes.
Do you know when that complaint was filed?
The specific time frame, I don't. I'll have to look. Approximately, I guess, around May of 2022.
Were you involved in, well, should I say, were the two photographs, you're aware of what the two, we've stipulated to the fact that there are two photographs on the website that in which you appear in your uniform, badge and gun in various groupings. Are you aware of which two photographs I'm referring to?
Yes, ma'am, I believe so.
We have those just identified in the record.
In the joint exhibit book in exhibit 7, which is already admitted. To that document, and I can read those joint exhibit book numbers in.
Yep.
First photograph is identified as JEB 0070. And the second photograph is identified as JEB 0072. Have those photographs been on your campaign website since it was approximately created in spring of 2022?
Yes, ma'am.
Are those photographs still present on your campaign website today?
Yes, ma'am.
And is your campaign website still accessible on the internet?
As far as I know.
I believe that's all the questions I have.
Okay. Any questions at this point for you?
Yes, thank you, Chair Dufferin. I'm gonna, with the commission's permission, just turn my chair a little bit.
Sure.
Trustee Rodriguez, could you briefly tell us a little bit about your career starting as a firefighter?
Oh, yeah. So at the age of 18, I began fighting fires with the federal government BLM. That's where I started my career. I was also a volunteer firefighter in the off season while attending TMCC fire science classes and courses. Shortly after the invasion of Iraq, I decided to join our National Guard. I served for 11 years as far as Afghanistan, Haiti, stateside as well. 2 years at Fort Irwin. So
I'm sorry, sir, 2 years at Fort.
2 years at Fort Irwin.
Thank you.
It's a booming metropolis. And so yeah, between my military service, I got into law enforcement with the state of Nevada back in 2006. After my last tour to Afghanistan in 11-12, I decided to get involved in other ways of our community, where I reached out to, at the time, my representative was Oscar Delgado, and got involved in 2 city boards with the city of Reno, volunteer boards, and eventually moved out to Sparks, where I reside today, where I continue on with my career with the state. I worked in corrections, patrol investigations to where I am now. So when I saw the appointment process, I decided to put my hand in the ring. I couldn't think of a better board to serve on than a school board, believe it or not. So I went through that process, the appointment process, which is pretty lengthy. You put yourself out there. I think I had like 19 or 21 other candidates for that seat, and I was ultimately selected as the appointee. So pretty much that's really my career in a nutshell. I'm not really a soapbox type of person, but that's who I am.
Was your appointment to the Washoe County School Board, was that your first elected or official office?
Yes.
And about how long have you been at the state law enforcement, state division of public safety?
The Department of Public Safety, I've been with the state overall, pretty much since 2006. There's a small break in service there. But specifically to the State Fire Marshal Division, approximately 6 years.
And want to actually use the photographs because I think they're in a little more context in tab 6 and exhibit 6. And these would be the same photographs that were previously referenced, but the pages that I'm looking at are ED 0025.
I'm gonna object because that exhibit has not been admitted.
So if I may, I have one suggestion. This is part of exhibit 6, which has, as I understand it, 5 separate documents in it. The first ones are JEG 34 to 39, which is the complaint, and that's already included as exhibit 1 in the exhibit book. There is Trustee Rodriguez's response to allegations, that's JEB 40 to 46, that's already stipulated to, and it's exhibit 2 in the exhibit book. There's JEB 47 to 49, which is Trustee Rodriguez's supplemental response. That's already stipulated to, and it's included as exhibit 3 in the exhibit book. The 5th one, just jumping ahead a little bit, is JEB 61 to 63. That's the commission's letter to Nevada Sheriffs and Chiefs Association. That's already included in the exhibit book as exhibit 9. So for purposes of exhibit 6, I would propose that the commission take it as though it only is JEB 50 to 60, which relate to Trustee Rodriguez's campaign website, and narrow the exhibit that way.
I would request that the whole, if we're gonna admit parts of it, I would request that the whole thing be admitted.
Well, we're only relying upon 57 and 58, and these are documents produced by the executive director, so I don't understand the basis that they would object to their admission.
It is an entire exhibit. It is an exhibit that encompasses everything that the executive director has produced in this matter. There are statutes that require what that production is. It is one document itself, just like the rest, and I would object if you would like to have it admitted, I'm happy to stipulate to the whole document being admitted.
I can only lay the foundation for these 2 pages, and I can do that through my witness, and then I move for the admission of these 2 pages.
I'll withdraw my objection. That's fine. We'll stipulate to just those 2 pages.
So just for clarity, just for the record, the commission in its discretion may relax the rules of evidence, and this would be a permitted relaxation if the commission, the vice chair allows it.
Sure, since the 2 parties have agreed just to having those 2 photos included in the exhibits, then I will agree to that.
And just for clarity, is that a stipulation to admission or just to allowing the introduction? And
Actually, I would request that we stipulate, it's part of Mr. Rodriguez's his campaign website, which is JEB 0050 through JEB 0060. I would request for context that I would stipulate to admit that entire range of documents so that the context of the 2 pages is clear.
Well, if you could provide me the page range, I believe.
Yes, JEB 0050. Through JEB 0060.
So stipulate.
Okay, thank you. I think we were at Mr. Osmer Henner. Continue, please.
Chair. Trustee Rodriguez, do you recognize photographs that you see on page JEB 0057?
Yes.
And is this the way they would generally appear on your website, campaign website?
I believe so, yes.
And were there any To ask more specifically, if you look at the photograph at the bottom left of page 57 and the top left of page 58, those are the two photographs in question today.
Yes, sir.
And were those featured as a standalone website or standalone picture on your website to the best of your knowledge?
No.
They were provided in context with the remaining pictures?
Yes.
And do you recall the date at which the photograph at the bottom left of JEB 0057 was taken? That's the one showing the dog in the fire costume.
Yes, sir. That was approximately around February 2020 before there's national shutdown.
And what were the circumstances that that photograph was taken?
That was pretty much there. So part of the state fire marshal, we promote fire safety. So we do visit schools throughout the state. And in this particular case, we were at a school within Washington County where we were just talking about fire safety. We were invited there by the principal of the school and we comply with their request to visit.
Do you recall who took that photograph?
I do not recall the person. I do believe it was a parent.
And was that, did you have any association with that parent or prior knowledge of that parent?
No.
At the time this photograph was taken, were you interested in applying for the Washoe County School Board?
This thought never crossed my mind.
And were you in the middle of any sort of campaign at the time this photograph was taken?
No.
And as part of this program where you appear in schools, does that require or entail you appearing in your uniform and badge?
Yes.
And this was a routine duty as part of your job at the Fire Marshal Division?
Yes, sir.
With respect to the photograph on page 58 on the top left, do you recall the date that this was taken?
I believe this was about the summer of 2019.
Is there any reason that you recall that specific date?
It was for the honor walk for Lizzie Hammond.
Sorry, sir, what was that?
Lizzie Hammond, Elizabeth Hammond, she's the young girl that died in the bounce house accident some years ago.
And was this a voluntary appearance you made?
Yes.
And other individuals from many law enforcement agencies appeared as well in uniform?
Yes, public safety overall, it was fire, medical, military, it impacted a lot, so yes.
Are you aware of whether there were media present at that event?
I do believe so.
And did they take pictures of people in uniform?
To that's my knowledge, yes, sir.
Do you recall any photographs being taken of you specifically at that time?
I'm gonna object on the relevance to the issue.
Our response is that this is a photograph that was not taken as part of this campaign, but was part of a series of photographs taken of a public event.
That's not what the question asked.
Go ahead and continue your questioning.
Did you request?
Overruled.
Thank you, Chair. Did you request that this photograph be taken?
No.
At the time this was taken, were you considering applying to serve on the Washoe County School Board?
No, sir.
Was the purpose of that this photograph was taken, or the other photograph, to the best of your knowledge, relevant to any of your personal benefits or gains?
No.
Objection calls for speculation.
My response is simply that he's aware of the circumstances related to these photographs and of his personal benefits. And while it may be the case that that parent several years prior to the taking of this photograph wanted to in the future benefit his political campaign, he can testify to the best of his knowledge that it certainly wasn't.
Would rely on our previous arguments that the issue is not when the photographs were taken, the issue is when the photographs were uploaded to the campaign website in order to bolster his campaign for trustee.
I'll overrule that.
The best of your knowledge, were either of these two photographs taken to support your campaign or future campaigns?
No.
To the best of your knowledge, were either of these photographs taken to benefit you in any way?
No.
At some point you provided all of these photographs to your campaign team?
No, honestly, there's more. This is kind of what was filed down through my team.
And can you tell me a little bit about the process that you use to choose the photographs to provide to your campaign team?
I went through all my photos specifically to show who I am. So there's quite a bit of photos I went through, my wife and other friends and family, just to give an honest representation of who I am through my campaign. So quite a bit of photos were given to my team, consisted of several people. And these were the photos that were basically that were decided. Specifically to what I do currently, I guess particularly these two photos that are in question. When I was looking, I mean, if I wanted to, I could have honestly been like, here's my patch, my badge. I could have been very upfront with what department division I worked for. I didn't want to do that. I did my best to that the layman person could tell, yeah, he works in law enforcement. That's what he does day to day. But it was by no means to be specific to gain any necessarily favoritism or prestige or whatnot. So the two photos that I did give were to the best of my ability to represent who I am, but not to, for lack of better words, to conceal my department, my patch, things of that nature. Vehicle.
Were there other photographs that you had that much more clearly indicated what your role was?
Absolutely, yes.
And would those have shown even more detail, names, insignia?
Yes.
While you were campaigning for office during 2022, did you ever campaign in uniform?
No.
Did you ever campaign with a badge?
No.
Did you ever show up at public events in uniform or with a badge as part of your campaign?
No.
Did you pose for any pictures during your campaign in uniform?
No.
Did you pose for any pictures during your campaign with a badge or other indicia of the State Fire Marshal Division?
No.
Did you appear in any advertisements endorsing any other candidates in your uniform or with your badge?
No.
Did you appear in any advertisements for yourself in uniform or with a badge?
No.
And the first time that you were aware of an issue potentially with these photographs, was that when you received a notice from the commission?
Yes.
And was the initial focus of that notice related to pictures related to your role as a trustee?
To the best of my knowledge, yes.
And can you tell me a little bit about that? About what you thought the inquiry was about?
Yeah, honestly, I was pretty confused. I wasn't sure if it was aimed specifically at social media, things of that nature, or quite frankly, we're getting attacked quite a bit, number of us candidates. So I understood that there's some sort of complaint, but that's at some point, that's where I personally searched legal help because I wasn't entirely sure what the issue was.
And did you receive a notice from the commission after the election relating to the review panel's determination?
Yes.
And at that time, was your campaign website relevant or being maintained?
No, I mean, kind of working in law enforcement, being familiar with the judicial system. I mean, if this commission dictates that this is an issue, I mean, I will be more than happy to take these pictures down, and I'll take the whole website down. If that's the pleasure for the commission.
I have no further questions.
I have a couple of questions. Is there a reason why you didn't campaign in your uniform?
Because one, I don't want to put my department in that position. Two, that's from the little bit that I know of just being a long time Nevada resident. I know Sheriff Antonero. I'm familiar with the Sheriff Chuck Allen's campaign. Plus, that's just common sense to me to not know. I'm not going to go in uniform on the clock. I mean, I just know within my own department policy that's fraud, abuse of funds. So that's why.
Thank you.
Vice Chair, I think there may be a little confusion as to which case we're on. Technically, I think Mr. Hosmer-Henry's presentation could qualify as cross-examination, but I don't know if you want to present your own case as well.
Similarly, the summary judgment, the issues overlap significantly, so we don't think it's necessary to redo the examination for the sake of having our own separate case in chief, and would incorporate all of that testimony in ours. There may be comments I want to make after the close of the executive director's case in chief, though.
Okay, so. All right, so Ms. Bassett, are you closing your case at this point?
Yeah, I was gonna make that.
Sorry, I think before we close the comment here. commissioners
Oh,
have questions.
yeah.
Yeah, so I think both parties are okay at this point. I would like to have questions from the commission. And so I'm gonna start with Commissioner Grunwald.
Hi,
Hello.
Mr. Rodriguez, I want to thank you for all of your public service. I admire everything that you've done and are doing now.
Thank you, ma'am.
Did you know that the two photos that we're really talking about were on your website?
Yes, ma'am. I did do a final review from after my team said these are the photos we would like to use. And so yes, I am aware.
Were you aware that members of the public were viewing these pictures on your campaign website?
I would sure hope so, ma'am. Yes.
I have no other questions.
Any other questions or concerns by the other commissioners? Commissioner
Vice
Oster.
Chair Duffer- Mr. Vice Chair Dufferin, just a couple of quick questions, if I may. I do appreciate your public service, sir. From your, the things you did to protect our country and the things you continue to do to protect our state. Thank you. How often, did you have paid campaign staff or were they volunteers, sir?
It was a combination of both, sir.
Okay. Do you remember who specifically, were they paid or volunteers that reviewed your website?
Yes, it was a FGP Consulting was the paid, was my campaign manager.
Okay. So they were compensated for their management of your campaign.
Yes, sir.
Okay. How often did you personally review your website?
Honestly, not a whole lot.
I know the feeling. Did you have meetings on a regular basis with your staff about your website? How many hits it was getting, how much publicity it was getting, those kind of things, any kind of way to gauge whether it was effective or not, or whether you needed to change things up?
In the beginning, sir, a little bit, I guess, when we started taking off, we did talk about the website. Obviously, it was kind of a big piece of our campaign initially, but then after that, I mean, we're talking about what precincts, what doors to knock on, getting people meet and greets. So discussion about the website got the back burners quite a bit afterwards. I mean, I did have people that would check on it for me, but it was not a big topic.
I don't know if I'm allowed to ask this question. I'm going to ask it anyway and get spanked if I ask it inappropriately. Did you at any time believe that the pictures that you put on that website, the only two we're talking about specifically right now, are the ones of you in uniform and the one of you in the school, were inappropriate to have on your website or would violate any rules?
To my knowledge, no. I mean, if it would have been, I would not put them up. But I thought, honestly, sir, if I thought this would lead to today, by no means would I have used these photos.
So if you knew then what you know today, you wouldn't have done that?
Absolutely.
Okay. Thank you. No further questions, Mr. Vice Chair.
Thank you, Commissioner Lowry. Any questions? I know you don't. Thank you. I had just follow-up questions on Mr. Rodriguez. You had stated on a prior answer about photographs. Did the number of photographs that you were given or you gave to your individuals that helped you with your campaign, you gave them a bunch of photos and they came up with the photos, and you obviously approved all these, I'm assuming, to put on your website. Is that accurate?
Yes, sir.
So the two photos in question, which has your accoutrements, your badge and your uniform. In the other state fire marshal photo, there's one that I guess you can kind of see your gun in there. And you've stipulated that that's accurate. So was there a specific reason, other than what you've already stated, why you picked those two and stuck those on the website out of all the pictures that you could? What was the specific reason why you chose those two photos, including it with all the others?
Yes, thank you, sir. Simply, it can, for lack of better words, you cannot read what my patch would say. You cannot see that as the valid. You couldn't tell whether I was a Eureka County deputy or, a Walmart security greeter. I don't know. So I try to do my best to, just for my department, to for lack of better words, kind of conceal the patch. You can't read my badge. You can't read the insignia. You can just tell, like, oh, to the average voter, the person next door, okay, I can kind of make out what he does. And then you can go in and further read about who I am and what I do. So I'm just validating who I am.
Thank you. Earlier, you also stated that it was probably inappropriate for you to campaign with your accoutrement, with your uniform in public. So I'm still trying to figure out the difference between that, which you seem to fully understand, but yet putting the picture of that on your site. So I'm grappling with that.
Sir, if I may help.
Sure, please.
I'm not a career politician by any means, but I can also, again, kind of going back to being a long-time Nevada resident, and just through RGJ, just through my prior knowledge, and honestly, if I may, just through common sense. I mean, like, I am not going to go in my full Class A uniform, knocking on doors, saying I'm a trustee. And, the prestige, especially given this current climate and view of law enforcement, I'm definitely not going to do that. So I'm just trying to give an accurate representation of who I am and what I've done. And again, these photos were taken long before even my appointment process. There's no guarantee I was going to get that appointment. And as far as running the campaign, there's also policies and procedures which I adhere to with my department. I cannot, as a fire marshal or a trooper, a Capitol Police officer, a governor's dignitary protection agent, I cannot do that. So obviously that'd be breaking the rules, and I know better to do that. As far as I know, to my knowledge, I was not doing that here. So, I mean, and again, I can't go back to the former commissioner's question. Like, if I knew these two photos were going to lead me to today facing a $5,000 fine that frankly I can't afford, especially on my trustee's salary that I'm benefiting from, I would not have used these two photos. So I like to think that, given at that time, I know the difference between right and wrong. I know not to go knocking on doors wearing my uniform. And I just hope that clarifies, sir.
Yes, it does. Thank you. Any other questions? Any other commissioners have any questions? Commissioner Grunwald.
I have one more.
Yes, ma'am.
Well, after you received the complaint from the Ethics Commission, why did you still have the pictures on your website?
Again, kind of going back to, if the commission does decide that this is an issue, I mean, I was being investigated. I mean, I get an investigation, just do my day job. Like, I'm investigating, there may be something going on here, but until this commission decides that, yes, this is an issue, then by all means, I will take it down. I spoke to my counsel, I spoke to my team, and that's kind of, where we led to today. I mean, I'm more than happy to take that down if that is the wish of this commission.
Thank you.
Okay, I think we're ready for closing.
We'll close in arguments, yeah.
Oh, sorry.
Yeah,
Yeah. And so you're not present, you've presented the evidence you wish to present in your case already.
That's correct. And we can move the close.
Thank you for clarifying that. And so I'm ready for closing statements from each party, and I'm going to limit that to 15 minutes. And let's start with the executive director.
A procedural.
Sure.
If we could there are sort of two issues and one only follows a certain finding. You know, the issue of willful versus non-willful becomes relevant if the commission finds that there's a violation. So I was wondering if I could separate out my closing argument to arguing whether there's a violation and then address willfulness if there's a finding of violation.
Well, I think what I planned on doing was, once we hear both closing arguments, is to take a recess and actually probably deliberate privately with the commission. And so what I'd rather you do is just to go ahead and do your complete closing argument with the willful and then non-willful, if you don't mind.
Absolutely.
Thank you. Clock starts now.
I can't circle it. As this commission has heard, the executive director is alleging two violations of the ethics law by Mr. Rodriguez. The first of those is NRS 281A.402. To prove a violation of that section, the executive director must show that Mr. Rodriguez is a public officer or an employee, and that he used his position in government to secure or grant unwarranted privileges, preferences, exemptions, or advantages for himself. As the parties have already stipulated, and as you heard Mr. Rodriguez during his testimony today, he is a lieutenant of the Nevada Fire Marshal Division and a trustee of the Washoe County School District. He is employed by the state of Nevada. And Mr. Rodriguez is therefore a public employee to whom the ethics law applies. As to the second element of 400 subsection 2, this commission has established a hard line under 400 subsection 2 prohibiting a public employee's use of the physical accoutrements of his office or position to bolster his endorsement of a person's candidacy, including his own candidacy. The commission has stated that the reason for this hard line is that the use of such accoutrements of the public office provide the impression that the public officer is acting in an official capacity and that the candidate is endorsed by the law enforcement agency represented. This provides a candidate with an unwarranted advantage that is prohibited by NRS 281A.402. That is something this commission has already decided. And it provides an unwarranted advantage over the other candidates in the field. Because it does appear when you wear your uniform and that you are endorsed by that law enforcement agency that's represented. Mr. Rodriguez has testified he posted 2 pictures to his campaign website showing him wearing a state fire marshal division uniform, badge and gun. Thus, based on this commission's previous precedent and the facts that are stipulated to him and testified to, both elements of a violation of NRS 281A.402 have been established by the executive director as to each of the photographs at issue. Thus, the executive director has established by preponderance of the evidence that Mr. Rodriguez committed 2 violations of NRS 281A.402. As to NRS 281A.400 subsection 7, to prove a violation of that code section, the executive director must show that Mr. Rodriguez is a public officer or employee, which has been done, that he used government time, property, equipment, or other facility, and that the use of that government property was to benefit his significant personal or pecuniary interest. We've already established that Mr. Rodriguez is an employee. Mr. Rodriguez testified today that he participated in and posted the 2 photographs to his campaign website in support of his election for trustee, and they show him wearing his state marshal uniform, badge, and gun. This commission has determined in previous matters that public employees may not use government property, including uniforms, guns, and badges, in support of any campaign, including their own. In fact, this commission has definitively concluded that no state or local law enforcement official, including an elected incumbent official, may wear his or her uniform, badge, or other physical accoutrement of office in support or opposition of a political campaign, including his or her own campaign. Such use constitutes a violation of NRS 281A.400 subsection 7. That precedent is clear. The second element that Mr. Rodriguez used government time, property, or equipment to bolster his campaign has been satisfied. As to whether Mr. Rodriguez had a significant personal or pecuniary interest in the use of those photographs, this commission has previously held that an incumbent public officer has a significant personal and financial interest in maintaining their elected position. Mr. Rodriguez testified that he was running an election to retain the trustee seat he was appointed to. He also testified the purpose of the pictures on the campaign website were to support his election to that seat. Mr. Rodriguez has also testified he receives a financial salary in his trustee position under the ethics law. Therefore, he has a pecuniary interest in retaining his trustee position and the salary that comes with that, as well as retaining his seat. And that satisfies all the elements for a violation of NRS 281A 407. As to the issue of willful versus non-willful violations, Mr. Rodriguez has testified that he knew there were rules that prevented him from using his uniform. He was aware that there are rules that are internal to his organization. The question of willful versus non-willful is the only place where his intent and his thought process becomes relevant. It's not relevant to whether he committed the violations, but whether those violations are found to be willful or non-willful. I would argue that Mr. Rodriguez was aware of the ethics rules, but did not comply with them fully. Whether he thought that would be a violation or not is again not relevant to whether there is a violation. But he was aware there were rules, and he did move forward anyway in having pictures on his website that are a violation of the ethics law. That this commission has determined that those kind of violations are serious violations based on the impact they have on viewers of the photographs. Mr. Rodriguez has testified he maintained the photographs involved even after receiving notice of the investigation, and that they even remain on his website today. Additionally, Mr. Rodriguez realized a financial gain as a result of his violation through his salary. And because the campaign website solicits and accepts monetary donations, therefore he did have a financial gain, which is also a factor towards finding willful violations. We continue to request the same penalties as were argued for in the motion for summary judgment. And since I went in depth there, I will leave it there.
Thank you. Mr. Hogmer, enter your turn.
Thank you, Chair Dufferin.
Mr. Chair, I'm sorry if I may, can I move over? toward
Please
him?
do.
I don't know why I'm having a hard time hearing him.
Try my best.
Pardon?
I'll try even harder.
Okay, please continue.
Thank you. This case comes down to one issue, and it's whether it is the same to take your uniform and badge and go appear in a political advertisement while you're running for office versus taking a photograph that was taken before you had any conception of running for public office and putting that on your website. And this commission and the counsel for this commission believes that there is no difference between those two things. But the statutes and our precedents say that there is, and there's a reason that the other jurisdictions are relevant. There's a reason that this commission's prior decisions are relevant, because none of those address a situation where someone appears in or uses a photograph that was taken prior to running for office, even if that includes the indicia of their prior law enforcement service. there are two statutes at issue. One is subsection 2, and that is using your position to secure an unwarranted privilege. How did Trustee Rodriguez use his position as a law enforcement officer to secure an unwarranted position by appearing at a school in 2019? How did he use his position as a law enforcement officer to take a photograph that was created not by him and not at his request and not as part of a government program to then post that on his campaign website? If the photograph is not government property, then it can't be using that government property to put it on his campaign website. There is an important distinction here because the statutes relate to using an office and they relate to using your public position to secure an unwarranted privilege or using government resources. Trustee Rodriguez didn't use any government resources by posting a photograph to his website. So at a minimum, the complaint with respect to subsection 7 must be dismissed because there are no government resources at question with respect to his use of that photograph, which was not government property. That is different than a situation where someone creates a photograph using government property for the sole purpose of having that photograph. For instance, if you film within an office inside a school or use school resources or children to stage a photograph for your campaign, that is a use of government resources to create a photograph. There was no use of government resources to create a photograph by Trustee Rodriguez here. He took a photograph that existed and used that photograph, which is not a government resource, to put on his campaign website. So that disposes of subsection 7. With respect to subsection 2, the language is clear that a public officer or employee shall not use that position to secure an unwarranted privilege. The difference would be someone using his position to show a badge and a campaign and knock on doors in uniform, which his opponent could not do, versus this situation where he was not using his position in law enforcement to obtain any advantage. And in fact, his opponent, if this commission were to hold otherwise, his opponent can use that photo, but not Trustee Rodriguez. That's what this decision would mean, is that he can't use the photograph of himself in his prior public service, but his opponent can. How could this commission possibly draw that line that would disadvantage the public servant rather than his opponent over the same same photograph, which is not government property? We think that there is a difference and that there is a bright line between current use of government resources, the staging of a photograph, appearing at a campaign debate in public uniform, and appearing in a political advertisement or a campaign advertisement uniform, and taking a photograph from the past and putting it on a website. If this commission were to fashion a rule, we would submit that this is not a violation at all. But if this commission were to fashion a rule that splits the difference and that enacts a middle ground, it would be that these photographs, these historical photographs, which are not the use of government resources, should be accompanied by a disclaimer. And if this commission adopts that rule, as you heard, Commissioner Rodriguez is happy to take the photographs down completely. He was just trying to be a member of the community and to show his community service, but he's also happy to include that disclaimer. But one of the things that matters here is that there's not a single opinion from this commission that requires such a disclaimer of these photographs because the issue hasn't been addressed before. So with that, I'll turn to the willfulness issue. We don't believe there's any direct precedent from this commission saying that you cannot use historical photographs of yourself to accurately depict your prior public service. Not one of these decisions squarely addresses that issue, not Antonoro, not Kirkland, not Kuzanik. None of these address those issues because in each of those circumstances, and maybe it takes time for certain people to get the message, but in each of those 3 cases, they were actively appearing in their uniform at live events, at debates, and in commercials. None of those opinions addresses the conduct at issue today. That brings up the issue of kind of one of the requests for relief, which is ethics training. And our response will be on what? On what opinion have you been able to point to from any jurisdiction or from Nevada that talks about this issue of historical photographs or photographs that aren't being created through the current use of government resources? There isn't authority, there isn't training, there isn't a manual for a public officer on what to do in these circumstances. And if you look at the intention to violate, Trustee Rodriguez created a campaign website and approved dozens of photos. Some of those include his military service, appearing in military uniform, because that's permissible. But a candidate, again, can only not use his law enforcement uniform, because that's impermissible. So you can understand why that's slightly confusing to a non-career politician who is authorized to use and show them their military service, but not authorized to show their law enforcement service. But they can appear in the photographs can be in uniform on both circumstances, but only one of those is prescribed. That creates a difficult bright line for individuals to follow. And then finally, with respect to the issue of why he perhaps didn't take down his photographs as promptly as possible, this commission may recall that there were numerous complaints filed against school board members around the same time as Trustee Rodriguez got his complaint. And that complaint and the others all appeared to relate to the social media and campaign websites of these individuals with respect to the use of schools. So initially, Trustee Rodriguez, as he testified, believed this was about his appearance in school. And so his response to the commission was, well, don't worry, I wasn't using school resources to create that. That was, for my campaign, that was taken prior to my campaign. Only then, after a supplemental request and a supplemental response from the commission, did the actual issue become more developed. So it actually began to be an issue about the uniform. And again, by that time, the election was over and there was no further, he wasn't trying to gain any benefit or drag it out to obtain any benefit. It simply was a non-issue. If it had become clear from the beginning that the issue was about his appearance in uniform, perhaps his response would have been quite different. So in sum, what we would say is incorporating all of the arguments from our summary judgment briefing and earlier today, that there is a fundamental distinction between the use of government resources and the use of your public position to create content versus the use of prior historical content. And only one of those situations has been clearly prescribed by this commission's prior opinions. Unless this commission has any other questions, we'd be happy to close on that. Thank you very much.
Thank you. Any other questions from the commission? Seeing none, I believe we're now going to take this in a private meeting and deliberate, which I'm told we can do. All right, so let's take a 5-minute break and then we'll resume a private deliberation meeting. Once we conclude that, we'll go back on the record. Okay, we have go back on the record. It's 1:42, Wednesday, 1/15/2023. The commission has deliberated and has come to a decision. Does any my fellow commissioners want to make a motion?
I would make the motion.
Commissioner Grunwald,
I move that the commission find that Mr. Rodriguez committed 2 violations of the NRS 281A.400 and 2 violations of the NRS 281A.400 7 which violations were willful, and that a fine of $250 per violation for a total of $1,000 be imposed. I also move for a reprimand and a requirement that Mr. Rodriguez attend and complete ethics training selected by the executive director within 60 days of the written decision being issued. I further direct commission counsel to prepare a final written opinion based upon the record and circumstances stating each violation alleged against Mr. Rodriguez and the determinations of the commission relating thereto, and including consideration of applicable law, findings of fact and conclusions of law, and any penalty, corrective action, or other remedy imposed on Mr. Rodriguez.
This is Commissioner Lowry. I would second that.
thank you, Commissioner Lowry. All those in favor say aye.
Aye.
Aye. Any opposed?
Aye.
Hearing none, motion carries unanimously. And that I believe concludes item number 6. Madam Chair, please take over.
Thank you, and thank you very much. Good. Next item. Right, next item is item 7, the Executive Director's Agency Status Report. Executive Director Armstrong, please give us your presentation.
Thank you. This is Executive Director Armstrong, and I will be brief in my report today. There's a written report submitted under agenda item 7 on education and outreach. I will just note that our online learning management system, we've gone through the coaching period, so I want to thank Barry and Darcy for me, so I'm not the lone wolf on going through those coaching sessions on how to set up our system. It's exciting. It's kind of like it's a gift that you are excited to get, and then it's a whole bunch of work. So we kind of have some planning to do, and then we got some content creation to do, but I'm hopeful by summer that can be up and running and will be helpful. So there's some great things to do with that learning management system and some customization. So that's exciting, and I'll have more about that when we have more to show you. Legislative update. This is the 38th day of the legislature. There's a legislative report. We have had our budget hearing. We've had our initial hearing on our bill. We worked with the city of Henderson on some requested changes to our bill and submitted those. So it should be ready for work session. We haven't gotten notification of a work session date, but that committee hasn't work sessioned any bills at this point. There was one bill that sought to help protect individuals from having to I guess disclose their membership in a nonprofit organization as part of just personal privacy. And so I talked with the sponsor because I had concerns that would undermine NRS 281A.420 and disclosure requirements when you have a commitment in private capacity to a nonprofit organization. And so just this morning, she sent amendment language that would make it clear that does not, you're not protected from the ethics law if that's the situation. So that's good. That bill will be amended. There's a handful of open meeting law bills that are out there. And some others about commissions need to reflect the diversity of the state of Nevada, and that also we would have timing requirements to let the governor know of a vacancy. So that's about it for boards and commissions stuff. And then a budget update. Like I said, our hearing is done. We sent follow-up information, which is great. For this fiscal year, we're on track. And then commission council hiring update. We have posted the position. It closes next Friday, so we did a shorter application period in hopes that would help us secure someone. We do have, I think, 2 individuals that have applied that at this point we would recommend for interviews. And then not in the report, just a note for the April. Well, let me thank Darcy for the stuff today. There was lots of materials preparation and booklets and stuff. And so I want to thank Darcy for all her hard work on that. And then in the April meeting, depending on what occurs really in the next 7 days on the Blundo case that we heard earlier today, that may be like a 2-night. I anticipate maybe a potential very full day in April for that commission meeting. And we continue to process lots of cases. You guys have all experienced it because you get all the emails. But we have lots of cases that we continue to process, especially advisory opinions that have come in at a very fast rate. So that's it for my report. I'm happy to answer any questions.
Fellow commissioners, any questions, comments?
No questions?
How are you guys managing to hold up with the increased workload and short one person?
We're hanging in there. I will tell you, I think the most unanticipated work. This is what I'll say. In terms of the number of cases coming in for complaints and advisory opinions, we're at now where we were towards the end of April last year in terms of the volume that's come in. So we're like a whole month and ahead, a half of the pace of incoming stuff. As you guys have seen, there's been a handful of like kind of groupings of complaints against people that are not in our jurisdiction. And so even though those are pretty simple to get rid, I mean, there's still a lot of time on those. And then really what we have is the advisory opinions. And so Liz has been doing a great job of kind of grabbing that bull by the horns and is focused on advisory opinions and working with Darcy. And then I'm kind of taking the investigation lead and working with Aaron on those. So we are managing, but it is definitely a challenge at this point without that commission council person, because there's a lot in that processing, especially I think most noticeable in that advisory opinion process. Lena has been great. Liz was out for a week, and so we sent documents for Lena to review that Liz would normally review, and she did great and was quick in responding back to us. So it's just, we're seeing an unprecedented volume of cases come in, and being down one it's kind of it's a double whammy. Yeah, and legislative session, which
Yeah.
is a whole other beast. So
Everything else.
yeah.
And I just want to go and let the other commissioners know that Executive Director Armstrong did a fabulous job on the budget presentation.
Thank you.
I think it went very well, and when he presented on our bill, that went very well as well, and he's kind of ahead of the curve and, you know, really addresses the issues that are at hand, and hopefully we can get some upgrades for our staff. Yeah. With that, I also want to thank our Deputy Attorney General St. Jules for all of her help and everything, and thank you so much for helping them when the Commission Associate Counsel was out of town, so I appreciate that.
My pleasure, anytime.
So thank you very much. Well, with that, I will go and call for a motion to approve the Executive Director's report as presented.
I'll second.
All right, all those in favor say aye.
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 Opposed? Motion carries. Item 8, Commissioner comments. Are there any commissioners that would like to make any comments or put future items on the agenda?
Madam Chair,
Yes.
I'll make this super brief since I've already talked too much today. Just a comment regarding our training that we do. Just want to make sure that we include the types of issues that we heard today in our training, specifically the accoutrements of the office training, and make sure that I'm sure you probably touched on it already, but you might want to highlight that, and make sure it's in there. And I just want to make a shout out to Linda St. Jules helping me prepare for the items that we heard earlier today. I wanted to thank you on the record. She did a great job getting me ready for that, and thank God's staff for getting all the materials out. Appreciate that. And I'll shut up for now. Thank you.
All right. No. Commissioner
Madam Chair.
Oscar. Yes.
First off, I'm grateful that Commissioner Dufford is done speaking. Secondly, I want you to know that I have not worked with a group of people, I don't think, that comes together like this would do in the face of being down one person and everybody picking up the slack and doing the things that they do, and having somebody help us, like our counselor. I don't try and pronounce your name, counselor. That's why I call you counselor, because I don't try. I'm not gonna mess it up, so you can't accuse me of that. But I'm truly grateful, and today was truly an example of the talent that's on this board through the deliberations and through the discussions with my fellow commissioners, but the attorneys and their legal knowledge and expertise was invaluable to me and helped me work through some things, some conflicts that I had with different processes. So very grateful for that, grateful to be a part of the commission, and grateful for everybody, including Vice Chair Duffin.
Thank you, Commissioner Oscarson, for those comments. I don't see any others. So next item is public comment. Executive Director Armstrong, are there any members of the public present?
There are no members of the public present, and we have received no email public comment during the meeting.
Are there any members on Zoom who wish to comment?
We have no members of the public on Zoom.
That wish to comment? All right. Well, with that, I will entertain a motion to adjourn.
I'll make a motion to adjourn.
Do I have a second?
I second.
All right. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Thank you very much, everybody, and we'll see all of you in Vegas in April.
Thank you, everybody.
We'll switch over for Commissioner Lowry, Vice Chair Duffin, and the end to the panel Zoom. And we can begin unless Commissioner Lowry, the presiding officer, do you need a break or?
No, I'm good to go if everybody
Yeah.
else.
I'm ready.
Awesome.
Ready, but I